for the private respondent, and this matters pertains to Arunachal bench. And there is an order from the Honorable Chief Justice acting to resend the back send the
Send the-
file after reopening.
Okay, you wanted there.
There.
Heard Mr. A. Learned Counsel for the petitioner and Mr. A. Chetri, Learned Counsel, appearing for the respondent number 6. Also, the Learned Counsel for the parties have submitted that in terms of the directions passed in the matter by the Honorable Chief Justice, while permitting the matter to be moved, to be filed and moved before this principal, Learned Counsel for the parties have submitted that the issue arising in the present proceeding had so arisen within the state of Arunachal Pradesh, and it falls, and accordingly the matter falls within the jurisdiction of the Itanagar bench of this High Court. The Learned Counsel for the parties have submitted that the Honorable Chief Justice, while permitting the petitioner to file and move the petition before the principal bench of this court, had required the case to be transferred to the Itanagar bench after passing of orders and on conclusion of the vacations. So, accordingly, the Learned Counsel for the parties have submitted that the registry be directed to transfer the present petition, records of the present petition to the Itanagar bench of this court. Full stop. In view of the above submission, the registry is directed to take requisite steps in the matter in accordance with the directions issued in the matter by the Honorable Chief Justice. Full stop. In the event any approval of the Honorable Chief Justice is so required in the matter, this matter be placed before the Honorable Chief Justice before transfer of the present records. Full stop.
Interim order.
Interim orders passed earlier to continue till the next date of listing of the matter.
Obligement.
Mention item 54 Lordship.
Item?
54 supply.
Yes, Mr.
In this case, we file an affidavit in opposition for 9, 10, 11. This may kindly be called for in the record.
Dumping.
Yes, my lord.
What happened? Clear.
My lord, there is something in this case. We have filed an affidavit in opposition. This may be wrong.
Have you informed the other side? No.
Yes, we have filed the.
Matter has been, it's pending before or you have gone to the reference order you have gone to the Mr. S. Banik, Learned Counsel for the petitioner on instructions submit that he be permitted to withdraw the present writ petition inasmuch as the matter is being, the grievance raised by the petitioner in the present proceeding is being considered by the executing court. Full stop. In view of the prayer is not objected to by the Learned Counsel for the respondents. Full stop. In view of the above, the present writ petition stands dismissed on withdrawal.
May please, my lord. My lord, as regards item number 6, my lord, we have submitted adjournment request yesterday also, my lord. But Mr. Goyal is out of session and we were supposed to file our rejoinder also, my lord. That has also not been filed, my lord.
Adjournment slip has been circulated on behalf of the petitioner. Whether there is any, you have not, I think you have not taken the signature.
Oh, met, my lord.
Who? SC Revenue.
And
Any objection in adjournment of the matter? And a very serious matter.
true, my lord.
Very serious matter.
True.
If this is the way, what happened to the criminal proceedings, Mr. Vachaji? Any idea? That Nunmati land? Huh? A prayer is made on behalf of adjournment slip has been submitted on behalf of the petitioner for an adjournment in the matter today. Said prayer was not objected to by the Learned Counsel for the respondents. Also, accordingly, the registry to list this matter again on
2 weeks, my lord.
22/8/2025. Also, on the next date of listing, the Learned Standing Counsel Revenue shall apprise this court with regard to the stage of investigation in the criminal proceedings instituted with regard to the issue involved in the present proceedings.
Obliged.
Yes. What happened? Not doing?
With the consent of the other side,
Oh.
my lord, I beg to mention item 34 and 35, my lord.
Why? What happened?
My lord, I need further 10 days time, my lord,
Why?
to file a reply, my lord.
Mr. K.I. Muzumdar, Learned Counsel, appearing for the respondent number 5 in WPC number 2162, 2024, and for the petitioner in WPC number 2434, 2024, has prayed that he be granted 2 weeks time, further time, to complete his, to bring on record further pleadings on behalf of the where you want to bring in? First item or second item?
Both, my lord. In the
To
second-
bring in further
from the-
pleading on behalf of the party respondent represented by him in both the above noted petitions. Prayer is not objected to by Mr. M.H. Raj Barbhaiya, Learned Counsel, appearing for the petitioner in WPC number 2162, 2024, and for the respondent number 5 in WPC number 2434, 2024. Full stop. Accordingly, registry to list this matter again on 26/8/2025.
I love this one.
Have you listed before your lawsuits, my lord? Otherwise, office gets confused.
Will come, don't worry. Why? That settlement of fishery, have you informed the other side? Ms. S. Chutia, Learned Counsel, appearing standing counsel AFDC. Appearing for the AFDC respondent submits that she be granted further 2 weeks time to file an affidavit in the matter on behalf of the respondents represented by her. Prayer accepted. Registry to list this matter again on 27/8/2025. Is there any interim order here?
No.
No.
May I please, Your Lordship?
I can't take up.
Yes, sir. Yeah,
Item number?
12.
Item number 12. List this matter before any other bench without me.
Public.
She has come back? No.
Yes. It's not a.
Lordship, in this case, I am appearing on behalf of the petitioner. Lordship, I am be allowed 2 weeks time to file reply against the affidavit in opposition filed by the respondent.
They learn it.
Yes, sir, they filed.
You want to file an affidavit?
Already filed, Lordship. Yesterday filed.
Okay. It is submitted at the bar that an affidavit on behalf of the respondent number 4 has been filed on 31/7/2025. However, the same is not on record. Also, the Learned Counsel for the petitioner submits that he be granted further 2 weeks time to file his response to the affidavit so filed by the respondent number 4. Also, prayer accepted. Registry to list this matter again after 2 weeks along with the pleadings brought on records by the parties in the meanwhile. Also,
Lordship, interim order was the interim order.
I'm coming to that. Interim order passed earlier to continue till the next date of listing. I'm aware of that. Don't worry.
I please, Lord. The consent of the other side, I beg to mention item number 11, Lordship. What happened?
You're there.
Somehow misplaced the brief, Lordship. Lordship may kindly grant us 1 week time to reconstruct the brief, Lordship.
This is in that market. Huh? What right do you have there? It was a temporary allotment made. And there were others who had come up before this court. Preference was directed to be made. One ground of argument may be that notice or settlement process was not in terms of the Panchayat Raj Act. Your name?
W. Rahman on behalf of A. Shulman.
A prayer is made on behalf of the petitioner for an adjournment in the matter, to facilitate filing of a rejoinder by the petitioner. What do you want?
No, Lordship. Lordship, we have somehow misplaced the brief.
Oh, you have. A prayer is made on behalf of the Learned Counsel for the Learned Counsel appearing for the petitioner Mr. A. Sharma for an adjournment in the matter on account of certain personal inconvenience. Full stop. Prayer is not objected to by the learned counsel for the respondents. Para. Registry, accordingly, registry to list this matter again after 2 weeks on a date to be fixed by.
There's an interim order, Lord.
Interim order passed earlier to continue till the next date of listing.
Hello.
Yeah, go ahead. Registry to list this matter again on 18/8/2025.
Hello.
Annulment of your land settlement. Mr. D. Chaudhary, Land Counsel, appearing for the petitioner, submits that he be granted further 2 weeks' time to bring on record, to file an interlocutory application to implead the authorities of the Borderland Territorial Council as party respondents in the present process. For prayer accepted, registry to list this matter again after 2 weeks, along with the interlocutory application now undertaken to be filed on behalf of the petitioner in the matter.
And of the other side, I beg to mention item number 3, 4, and 5.
Adjournment slip circulated, adjourned 2 weeks,
But should same prayer for item number 27 to 29, your lordship.
16 and 17 also,
Yes, your lordship.
16, 17, same prayer, Aru, and
27, 28, and 29.
27, 28 and 29.
In 27 to 29, there is an interim, your lordship.
27 to 29 interim also, interim to continue. Baki eke wo.
16 and 17 also.
16 and 17 to interim also, if interim order, if any, comma to X. As is jolly mighty, but
May I please, Your
all of circulation.
May I please, Your Lordship? Lordship, with the consent of the other party, I would like to mention item number 14, Your Lordship. My senior S. Chaudhary was supposed to appear in this matter, but on some medical.
If Mr. S. Chaudhary is not there, Mr. Chando should have been there. It would have been more better.
But Mr. S. Chaudhary for some medical.
Ms. Gayan, you are appearing in this matter. What has happened after that? That is, when the case was filed from that day, you are saying acquisition process. But have you paid him the rents? He was supposed to give you an NOC. Has he given you that NOC? A prayer is made on behalf of the learned counsel for the parties for an adjournment in the matter with a view to complete their respective instructions. Prayer allowed. Registry to list this matter again on 29/8/2025. So the parties shall apprise this court on the next date of listing with regard to the present status with regard to the initiation of acquisition process, as well as the release of a rent to the petitioner for the premises, for occupation of his premises by the respondent authorities.
Obliged.
May I please, Lordship? Lordship, I beg to mention item number 8, Lordship. Kindly matter may be
What happened to the RFA 35?
take instruction. Lordship.
You take instruction and come back and tell me when the matter is called.
My senior is
RFA, go to the kiosk, RFA 35 2016, see what has happened and come and tell me. Mr. Roy, you are paying for? 16 matter, 2016.
Actually, take long time to file it, like, so I'll just take 1 week time, file it.
Mr. You are assisted by? Mr. B.P. Sharma, learned counsel, assisting Mr. J. Roy, learned senior counsel, appearing for the petitioner, has prayed for a week's time to bring on record a rejoinder to the rejoinder on behalf of the petitioner to the affidavit filed by the respondents in the matter. Prayer accepted. Registry to list this matter again after 2 weeks on a date to be fixed by.
May I please, Your Lordship? You would beg to mention item number 55 of the supplementary list. But in this case, we are supposed to file.
Thus the affidavit.
That's the affidavit. My lord, I pray for 10 days time, my lord. The petitioner.
Matter is just pending for that.
My lord.
Mr.
D. Kolita.
D. Kolita, learned counsel for the petitioner, submits that he be granted further 10 days time to bring on record the affidavit envisaging the service of notice upon the respondents by way of dusty service. Full stop. Prayer accepted. Registry to list this matter after 2 weeks on a date to be fixed by it, along with the said affidavit now undertaken to be filed by the learned counsel for the petition.
Obligement.
Yes.
Item 1.
They have lost interest. This court, while order dated 8/1/2025, had issued notice in the matter, and the petitioner was required to take steps for service of notice upon the respondent number 6 by way of registered post. Also, the office note dated 24/7/2025 reveals that the petitioner has not taken any steps in the matter for service of notice upon the respondent number date number 6. Also, today, when the matter is called up, none has entered appearance for the petitioner. Also, however, for the ends of justice, the registry to list this matter again on Six 8/2025. Also, in the meanwhile, if the petitioner does not take steps for service of notice upon the respondent number 6 on the next date of listing, this court would consider dismissal of the present writ petition for non-prosecution. By slip query better. By slip na lage pot idea.
7.
Payment of the contractual fees of the petitioner. My lord. Last occasion was directed to file affidavit in manner the water resource.
I don't understand all those things. When are you filing? You tell me. Tomorrow. Mr. R.M. Daslan, Standing Counsel, Water Resources Department, undertakes to file the affidavit on behalf of the respondents represented by him on or before 4/8/2024. Accordingly, registry to list this matter again on 8/8/2025 along with this said affidavit.
I'm obliged, my lord.
Yes, Mr. Chaudhary. 3, 4, and 5, there was a they had circulated a slip yesterday. They had not taken your consent. Kiman Dishomi, MLA 2. You are paying for whom here? Item number 3, 4, 5, 2 weeks question. An adjournment is sought for on behalf of the petitioner on the ground that the arguing counsel is indisposed. Full stop. Registry, full stop. In view of the above, registry to list this matter again on, we'll have it on 6th. We'll come in because I did not go through the file also because there was a circulation and it was written therein that the petitioner is indisposed. So I thought maybe we'll have it on 6/8, huh? 6/8. We'll have it on 6/8, Mr.
8.
All of day, what happened to the Ms. Butler? You are paying here. What happened to the RFA? It's still pending. RFA is pending.
It's pending, look.
The learned counsel for the petitioner has submitted that the proceedings in RFA number 35/2016, which has a relevance to the issue arising in the present proceeding, is still pending disposal before this court. So, in view of the above, registry to list this matter again after 2 weeks. Also, on the next date of listing, the learned counsel for the parties shall apprise this court with regard to the further development taking place in the matter. Full stop. You get your instructions, whatever it's. Next. Madam, is there any proceeding pending before the arbitrator now?
India is next in code number 10.
Timing would be difficult today.
Will be just coming.
You are paying for?
I'm appearing for the other and counsel. He's also.
Who is appearing for the PWD? Huh? Okay, time. When Mr. Sahiwala is available, just tell her. We don't want him to wait.
Obliged. 14.
Yes, Mr. Borman, man, what has happened?
Matter, Mr. Dinath is appearing, my lord. Actually, 99, some inquiry report was called.
Huh.
I have to take the up-to-date status on that, my lord.
Because there is an order here of 9922 wherein this court had.
Initially, petitioner wants to withdraw.
No, we are not permitting him to withdraw.
Order was passed and accordingly we have to.
What happened after that inquiry?
Status I could not obtain from him, my lord.
Ms. M. Borman, learned counsel appearing for the, none has appeared for the petitioner. Ms. M. Borman, learned counsel for the petitioner, for the learned government advocate appearing for the respondents, has submitted that she be granted time till 13/8/2025 to place on record, place before this court, to apprise this court with regard to the status of the inquiry directed by this court to be carried out in the matter wide order dated 9/9/2020. A very serious matter.
15.
So as per order dated 17/10, 2023. Sealing case record was called for, my lord.
That is, they have said they don't have that record.
That's correct, my lord. In fact, the India affidavit in opposition.
We have received some record in the office. After tomorrow.
Okay. Mr. H. Sharma, learned counsel for the Mr. Handig has also made this submission in the last again that the records are in vernacular. Bring the vernacular records, we'll see.
My lord, in fact, India affidavit.
They have said there is no records.
No, my lord. In one hand, my lord, they have stated that the record has already been stamped, my lord. Sent to for the Honorable Guwahati High Court.
Para
Para 3, my lord.
3107.
Yes. And on the next para, my lord, they say, my lord, there is no
The record is not. Naturally, the record is sent here, they will not have it. Mr. H. Sharma, learned counsel for the government advocate appearing for the respondent, submits that this matter be taken up again on Uthod Besi on 18/8/2025, on which date he undertakes to produce the records of the.
I'm not sure, Lordship, some record is lying in our office, Lordship. That is why I just want to verify.
Can it be on 20th?
20/8/20 for production of the records as directed by this court in the present proceedings.
Lordship, my name may be reflected so that.
Name of Mr. H. Sharma, learned government advocate, be reflected in the cause list on the next date of listing for the respondents. Mr. R. Chakraborty and Mr. R. Chakraborty, learned counsel for the petitioner, and Ms. N. Bodloy, learned standing counsel, Revenue Department, are present.
All right.
N. Bodloy today. The recording is N. Bodloy, not G. Hazurika.
Pleasure, Lordship. 18 and 19.
Yes.
Lordship will take up the first matter, 2348/2017. Your Lordship. Against an advertisement.
No, before we enter into some. The tender you are eligible or you were the lowest or the highest was of 2014. That was cancelled. Then we have a gap of around 5 years till 2019. The next episode is 2019, wherein an order was passed on 4/12/2019. Status quo. Before that, there is no order of interim order is not there before that.
No, that's what I forgot to see that. There was, what happened, like, then 4 different parts were put into.
I am only concerned with your part.
Yes, Lordship, what happened, why I am here, mentioning here, one writ petition, I also was, I was the leading lawyer there also. He withdrew it.
Go on.
He withdrew it, but he had some kind of adjustment with the respondent authority.
We are not concerned.
Yes. Now,
What has happened to the Mahal after that?
still, but then I came with a interim prayer, Lordship. I think there is an interim
4/12/19,
Lordship.
IA 4129/2019.
Justice Michael.
Justice
Yes.
Michael's order. Yes, what happened to the Mahal after that?
That area was inside the forest, Your Lordship. So that we have to get a clearance from the central government to turn that area into mining it, but we didn't get that clearance. That's
Where do I find that?
So
Yes,
before
it's
submission, Lordship goes
page
into.
20, Your Lordship.
page 20 of
Page 20 of writ petition.
which one?
For 2348.
This process is after it is settled, after it is, not before.
Mr. Hussain, I'm not
Yes, Lordship.
concluding. I'm only
Lordship.
trying to understand
Right.
before I hear you. I should also be come to your level with regard to the facts.
It is a very poorly drafted petition I have made in my life.
I've not even seen it. I've just gone through the issue. I have not had the honor to forward you five so and so, so and so.
21.
James Stone, he is Mr. Hussain Ahmed Mojib. No, this is with regard to 1D.
Lordship.
The stone quarry area.
Huh?
Yes, 1D, 1D.
Stone quarry area number 1D.
But here I don't find the name of the petitioner.
Lordship?
Page 20, Your Lordship.
1920, Hussain Ahmed.
Yes.
Oh, Hussain Ahmed Mojumdar, okay. Okay, this is the reason.
Lordship comes to this reason. Lordship will come at annexure 6, page 19. Oh, sorry, annexure 3, page 16. What process my colleague is pointing out is the process after the bid is open, then this process will be followed, Lordship. Annexures 3, page 16. Lordship will come to the second paragraph. Shall I read? Third paragraph is important. This process comes. And then after this process, they'll give me a letter of interest.
Now, did you appear before did you approach the concerned authorities for a diversion?
Lordship, Lordship.
What happened? So the page 16, the requirement is only after MOEF's final
Yes,
approval
yes,
as per
yes,
section
yes,
2.
Yes, what I did, I applied for all those.
Where?
Lordship, incoming. Lordship. Yes, Lordship, at page 26. This is the format we have to submit for his clearance, Lordship.
Then what happened?
Nothing happened. And after that, Lordship, petitioner was said, no, he'll be given the settlement. He was made to wait for a long period of time. When nothing happened, what they did, they again published a new advertisement. That's why I said that stone quarry was divided into 4 parts. Initially, when I submitted my tender, Beldanga A, Beldanga B, Beldanga C, Beldanga D. So what happened now, without cancelling, though they show afterwards that they cancelled it, there was no cancellation, no honest money return, and there was no No notice even given to that. Without following all these procedures, they again did a new advertisement where these 4, they have made it into one compact whole. And they gave into advertisement. So I challenge that advertisement in this petition, Lordship.
Miss,
Petitioner was even asked to collect the EMD money, Your Lordship.
No, it is not.
Yes.
Where?
At,
wait, we are EMD and all, we are coming. Now, if you come back to page 16,
Lordship.
you are still to be issued an LOI.
Yes. That is that condition.
How long will they wait for this process?
Lordship, before issuing LOI, I have to get this forest clearance.
You have last around 6 years. You have not. Have you met the party, the concerned authority who is to issue that clearance, a party here? They are not a party.
No.
You have no grievance against them. So why should we?
Lordship, I did not make him a party, Lordship, here. Because, Lordship, he is not the one. He was doing with his file. There's nothing wrong.
No. This page 26, this 26 process has to be taken to its logical conclusion before you can be issued a.
No, before this happened, this advertisement is given.
Fine. When did you submit this?
15.
5, 10, 15. Then what were you doing for 1 year?
Because they were asking me to wait. That process is going on.
No. Where is that material? Page 16, if we go simply, the penultimate paragraph. Only after obtaining so-and-so as per so-and-so, the area would be allowed for settlement after issuance of LOI from the higher authority. Now, this is of 4-3. You have to immediately go and have that thing done. You have to go.
No, because all this year, they have to issue some kind of office notification.
Where is that?
They did not.
No, where is your pleading to that effect? That this delay for 1 year is only because of the fault on the part of the respondent authorities. And the tenders were issued thereafter.
Page 30, Annexion 1. Notice what it states a lot. As user agency, individuals were applied to submit expressing intent and processing of the diversion proposal in RF areas under Nagar division. It is hereby informed to all interested individual agencies that only the highest bidder above the reserve price mentioned against the area will be eligible for further processing of diversion proposal of clearance section of the Forest Conservation Act 1980 read with as of and as for the orders of those points of. Name of the individual who attached to the payments. So first, by the NIQ, he submits. Thereafter, diversion proposal has to go. If there is no concern from the state, central government authority, that diversion, that comes in the complete violation of section 2 of the Forest Conservation Act. Because Forest section 2 of the Forest Conservation Act provides.
Whether there is any time limit for this approaching the authorities for getting this.
Lordship, here what the main issue is, Lordship, I'll show Lordship the other documents which they submitted. What the second one, I had to file a new petition because that former one was with one former petition was withdrawn. In that affidavit innovation was given, which brings into that there was no cancellation.
Where is your that? Give me.
That Lordship will come to 1566 to 2020. They say that the entire tender process was cancelled. I say, Lordship. Lordship will come here. Lordship will come to 1566 2020, page 53.
Of?
This 1566 2020. That with reference to the subject cited above, I am returning here with all quotation. They say that it's cancelled. This is the way it is. With reference to the subject cited above, I am returning here with all quotations in original in respect of the stone queries received earlier, which has been sent back by so-so, white letter so-so, for information necessary action. Now, Lordship will come at 9, Beldanga, at 8 is Beldanga stone quarry number 1D, then Kothalguri, Bheluguri. Then if this was cancelled, Lordship, how come this notice Lordship will come now?
Now, what happened to A, Beldinga, B, C, what has happened to those? They are operating.
No, nothing.
And Belaguri?
That is what I'm saying, Lordship. This will come to NHS 956. Had it been cancelled, Lordship, this does not include my Swan query, but there was some representation made by this Swan queries tenderer. Lordship, let's say, please, now the Chief Conservative Forest Nodal Officer writes to the Divisional Forest Officer.
What happened after this?
Lordship will see that 15 October and 20th.
I know that.
Yes.
We got it. What happened after this?
If it was at all cancelled,
Okay.
nothing happened.
No,
I don't know about what happened after this.
that's what.
Yes.
If this settlements were gone ahead, they had gone ahead with this, bring that on record. It is just a communication. To understand it, yes.
I have the instruction from the Secretary issued by this Environment Forest Climate Change Law, whereby they says this Mohal area, area of this Mohal is less than 5 hectares allotted. There's it says.
Why are you throwing these papers? You should have brought it on record by way of an affidavit.
Petition is after my filing of the writ petition, not before that. It cannot come into.
Now we cannot put that.
We are not looking into this. So
this one.
Okay. Understood. Now argue your matter in your manner you require.
2348 2017 Lordship.
Which you want me to, which is the writ petition you want me to take up? 2348.
2348.
Okay.
Lordship, here what I did.
Now go from the initial stage.
Initial stages.
Advertisement, NIDCL.
Yes. On 7/2/2014, the advertisement was floated. For
Where is that?
Annexure 1, page 13. Here this.
So this is for diversion proposal only.
No, this is for the settlement, Lordship. Inviting quotations.
And madam, this is rates of 2014. We are in 25 now. Why should we allow by allowing your writ petition, why should we allow the state exchequer to suffer?
Lordship,
If you have any grievance, if there is any damage caused to you, we will permit you to go before the single civil judge and claim those damages by establishing. But I'm not allowing the public exchequer to suffer.
In fact, Lordship, I got it listed this matter for a long time. All the times I got it listed, but I think they were taking more time from the government side. So it is.
Can't help it. Because we'll also have to be
Lordship,
careful with regard to.
Then, Lordship, I would say, let them settle in my present value of the.
That we cannot determine what the present value if there is no tender. Because 4 lakhs that day, it would be paltry today.
And
Peanuts.
Then I would say that advertisement also has to go. The second
Advertisement will also go.
Second one.
That
Second
is already under stay.
will go.
And they'll issue a fresh advertisement. You participate. Yes. Agreed? Agreed?
What, Lordship?
I'm not troubling you. But nothing more can be done here. Because you have not explained the delay. Why you went from.
Yes, I had explained
Where,
the delay.
where?
Why for filing the writ petition, Lordship?
No. Approaching for the submission of the diversion proposal.
Oh, yeah, I have stated here, Lordship. I have stated here. I'm coming.
Where? Because there can be no settlement in your favor without that diversion proposal.
Lordship, here at page 6, paragraph 5, that the petitioner further states his proposal bidding price being accepted by the concerned authority as highest regular bidder was asked to prepare the mining plan of the area to be diverted in the above mentioned stone quarry RF area, and also he was asked to obtain the approval from the Director Geology in Mining Assam. It is pertinent to state here that by an office communication dated so and so, that Divisional Forest Officer so and so.
This is what I was looking for.
The members, this I have done.
No. When did you submit this proposal before SIA?
Lordship, I'm coming to that. Had requested the member secretary Environment Authority Assam to accord the necessary environmental clearance to the petitioner to initiate necessary action. This is the Assam to accord the necessary environmental clearance to the petitioner to initiate necessary action for processing of the diversion process as he was the highest regular bidder. The comparative statement of the quotations and other relevant materials was enclosed therewith. That the petitioner states, next paragraph, page, that the respondent number 6 through a letter dated 23/5/14 had informed us respondent 5 about the invitation quotation so and so, so and so.
No, you take me directly
I'm
to the
coming.
consequence after 4/3/2014.
After?
That letter issued on 4/3/2014, which is there in para 5. What did you do?
Yes, now paragraph 7, this is continuing 2/6/2014. This is the process continuing, His Lordship, that thereafter the respondent 5, by a forwarding letter dated 2/6/14 to the respondent 4, had intimated the quotations of the bids received along with all supporting documents. It was also stated the successful bidder would obtain, in addition to other mandatory clearances, approval for diversion of the RF area under FC Act 1980, but this was not brought into my notice. I have stated here.
Madam, there is nothing there. What did you do
Lordship,
with
I'm
the,
coming.
where is your, when did you submit your application for SIA clearance?
I'm reading, Lordship.
Please.
That the office of the respondent 2, the principal conceived counsel forest, so in the said office memorandum, it was stated there was discussion held on so and so with the chief secretary respondent 1. And
This is an internal communication.
I'm coming. Why?
Hmm.
There was a time schedule prescribed. Then I'll go straight there. Next page, Lordship 8. Proposal submitted various user. This is important. Respondent 1, and there was a time schedule prescribed for speedy and effective processing of the proposals submitted by various user agencies for diversion forest land to be used for non-forestry purpose under so and so, so and so. Therein, the steps involved in processing of the proposals for diversion forest land and time schedule to be followed in each step by the concerned officers were laid. According to the memorandum, the first step involved the submission of proposals which was to be directly submitted by the user agency, that is myself, Lordship, to the principal chief conservator of forest and head of forest so and so, so and so. But the petitioner was kept in complete darkness regarding this office memorandum. The petitioner continuously at different interval of time had visited the office of respondent 5 and requested him to do the needful. The respondent 5 kept on assuring him that the process of handling over the query to him was under consideration. The petitioner, being simple person, trusted the same. The petitioner had come to know about the office memorandum stated above only in the last part of the month of September 2015. Having come to know, the petitioner immediately submitted a nodal proposal.
Now, why did you wait? Because there was a, no, there is already a communication to you at page 16.
Yes,
Page 16.
Yes, Lordship.
Penultimate paragraph.
This communication, 4/3/14.
This is a communication. You have received this communication?
Only when I got this communication, I came before this court, Lordship.
No, this is a 4/3/14.
Yes, Lordship. This was not given to me.
Where have you stated?
I stated here, I did not know about this communication.
4/3/14, you have not stated anywhere. Show me that statement. This is the communication which initiates the proposal for you.
Lordship, this was not under this one.
Where is, just show me a line somewhere. Ms. Chaudhary will take it up after some time. Kindly look into it. Otherwise, even that second part I can pass. We'll only dismiss the petition. We'll take it up when you are ready. We'll take it up when you are ready. Mr. Gugoi, be here when she's ready. Yes.
The respondent can't get instruction.
We have filed our affidavit.
(3D) notification issued. Mr. Das, your affidavit does not specify that. It's only a 3G estimate. There is no 3D notification. Then Mr. N. Das, Learned Counsel for the petitioner, submits that the matter be taken up on 22/8/2025 to facilitate him to complete his instructions in the matter. So, to list this matter again on 22/8/2025. No further adjournment shall be granted immediately to either of the parties.
One communication has been received by the.
You complete it. Till last date, nothing is there. You complete it, give it to me.
Number 2, 3, and 4.
Mr. Arboro, Learned Counsel appears for the NHIDCL authorities. That is the respondent number 2, 3, and 4.
22/8.
Yes.
23 to 24.
Before we hear you,
My lord.
there is one observation in the order of the state level committee,
My lord.
which is reiterated by you in your affidavit,
My lord.
that the claim of the petitioner before the authorities was that his father's caste stood degraded
My lord.
on marrying his wife. Where is that statement of the petitioner? You are for?
I am from the, my lord, my learned file will be repeating the item number 24.
No. Who is for Mr. Kodel?
My
You are appearing. Okay. You are from Mahendra Chauhan.
understood.
Now, from where have you made this statement? In paragraph 6, I suppose, of your affidavit.
Well, this is made by my learned file. This is my reply and in the order.
No. There is no such statement in his petition. Your affidavit is Mahendra Chauhan. Yes.
My lord.
Para 9. You come to para 12 of your affidavit.
My lord.
This is an affidavit by Mahendra Chauhan.
My lord.
Come to para 12.
12, my lord. That with regard, I'm reading from the beginning, my lord, that regard settlement paragraph 8 of the petition. The answering respondent reporting the correctness of the statement stated that the respondent now for issue the OBC certificate to the petitioner of his own declaration and claim of OBC without any preliminary inquiry conducted by the issuing authority. Hence, it is,
So,
then it is, my lord, here also 8 they have met, my lord.
Huh?
That is their, my lord, sentence, my lord.
no. I only want to know this from where you are making this where you are reviving the statement of the petitioner that his father's status changed due to marriage. Because the same line is there in the SLC report also,
My lord.
order also.
My lord.
We can come to the SSLC
My lord. Last,
state level committee
my
report.
lord, last order.
Where do I find it? Page 39.
My lord. That where is the deputy commissioner has submitted.
No.
My lord. The
Mm,
draft
you can
letters
come
the
to
committee carefully
serial number
examined.
4.
My lord. As stated by the respondent in the President All Assam Gorkha Sonmilon Paksa district that the caste of the male degraded by the intercaste marriage system to the lower caste. This is his statement, man.
From where? Where do I find that statement? Just show me that statement. No. Where is your statement? In a writ petition, I don't find any such statement.
Stated by the president of the Assam Gorkha Sammelan before the caste level scrutiny.
Because I don't find a statement to these lines in the writ petition. Mr. Chaudhary, have you come across any such statement? But this is the ground.
My lord.
If this is the ground, Mr. Chakravarti need not be given a hearing.
They have taken that ground. my lord.
No, where? Just show me that. You have also
Before the
reiterated.
SLC, my lord. Before the SLC, they have taken SLC.
No.
Recording
Before the
the-
SSLC.
Right.
Yes, where is the records? Forget it. You were directed to produce the records. We are having it on Monday. Get the records. Tuesday. Give him a copy.
My
Both of you. Only that statement
My
that he was a Brahmin because of virtue of
Wife-
his marriage.
Wife is
That is your case.
my lord.
Wife, she was not a non-Brahmin. His father became a OBC.
OBC by virtue of marriage.
If that is the ground, if he has pleaded,
My lord.
why should we break our head? One line order will do. He's
That
not
is their-
entitled.
Their pleadings, my lord.
You're not
That-
entitled.
they are
Welcome
before
upon and the whole line of judgments thereafter.
Before the SLC, my lord. They are pleading, my lord. They.
Mr. Chakraborty, is this your plea at any point of time?
Please progress. I want to hold my cards right now.
No, this is the curious. I'm anxious to know that. Because if that is your stand before the SLC, you don't have a case. That is the end of the matter. Your case is that you are a Podal and that is a Chetri, so OBC instead of Assam. Mr. Chaudhary, you will have only the role to play after the.
After this order of the committee, my
You have written to the authorities whether the cancelled or not.
It is not cancelled, my lord.
You seem to be very eager to have Mr. Chakraborty back in your
My lord,
fold.
we have not been in favor. Your worship will kindly see the page 39 order, my lord. Last, the copy has been endorsed to the Deputy Commissioner Baksa. He is
Page?
requested to cancel the OBC certificate.
Huh.
That cancellation having not been done, my lord, we cannot really.
Because what I find is that the district level authorities have all submitted reports in favor of Mr. Chakraborty. But the SLC comes to a conclusion that because his marriage, that is the stand taken, and Mr. Saran, that's a stand taken by the Gorkha Association. But Mr. Sarania goes a step further and says that no, this is the plea taken by the petitioner, the allotee. We'll not call petition, it will be confusing, the allotee before the SLC. So this is what is interesting now to be looked at. So, Mr. Das, on Tuesday, heard the Learned Counsel for the party, heard Mr. M. Sarania and Mr. B. Chakraborty, Learned Counsel, appearing for their respective petitioners. Also heard Mr. M. K. Chaudhary, Learned Senior Counsel, appearing for the Indian IOCL authorities, and Mr. R. M. Das, Learned Standing Counsel, Social Justice and Empowerment Department. So, Mr. Das submits that he would produce the records of the proceedings instituted before the state level scrutiny committee, leading to the passing of the speaking order dated 11/2/2021, cancelling a holding therein that the petitioner in WPC number 2093/2021 does not belong to the OBC community. Also, in view of the above position and as agreed to by the Learned Counsel for the parties, raised to list this matter again on 6/8/2024 for further hearing.
I'm funny.
If they don't furnish, come back and tell me at 2.
I love this.
Item 9.
Mr. Savila, item number 9.
It's a very short matter, my lord.
Yes, Mr. Dhar.
My lord, here you will also see, my lord, some dispute was there. As per the contract, my lord, the matter has to be sent to the dispute
arbitrator.
redressal committee. Dispute redressal committee has given the award.
And then they say that the matter is pending before the arbitrator. Now we wanted
Not
to,
arbitrator. They did not, my lord, approach within.
because the earlier order is whether there is any proceeding pending before the arbitrator.
Correct, but if you also see page 25.
Their affidavit.
No, my petition, my lord. The clause number 25.2.
Disputes.
Dispute review expert shall be paid daily so and so, contractor reimbursement expenses so and so, and the cost shall be divided equally between the employer and the contractor, where
Where
whatever
are you
decision
reading?
is this so and so.
Page 20?
Now, 25.
Okay.
The
Dispute review expert shall give a decision. Huh?
either party
Huh.
may give notice to the other to refer the decision to the dispute judicial board expert to an arbitrator within 28 days of the dispute review expert's written decision. If the neither party refers the dispute to arbitration within next 28 days, the dispute judicial expert's decision will be final and binding.
So when did the dispute
yes.
review expert give his decision?
My lord, here your lord will find, my lord. Oh,
My lord, my affidavit, right?
my lord. Page 4. They have given us, my lord, that page 75.
75.
October 2017. Whereas dispute judicial board's order is at page 46, 13/7/17. After 3 months.
Page 40? 13/7/17.
Yes, 13/7/17. So that is time barred, my lord. They cannot open it, my lord. They have to pay as per the.
Okay. What is your stand, Mr. Dodd?
Affidavit, my lord.
Hmm.
There are 8.
Hmm.
There are 7 even.
Hmm.
I'll just read, my lord. Para 7 and para 8, my lord. Every member of council Jain and
So para 8 is what we have to decide. How can, when you have bound yourself that within 28 days of that, what has happened before that has happened?
my lord, he approached after a period of 15 months.
Why did you not object to that? You also participated in the DRB. So that is gone. That is waived.
Not waived, my lord. Now we are raising it, my lord.
No, you can't. You can't. You have not assailed the decision of the DRB. Rather, you have a grievance with DRB. You say you have referred it to arbitration. That is beyond 28 days. Para 7, 2 letters. 13/7/13 is the order of the. What is the date of the DRB, Mr.
13/7/2017.
17. So 28 days you have not done it.
No.
You have done it in 13/10/2017. Now 25/3, where is clause 25/3 here?
Yes, my lord. That is at page 25. As far as this one is final and binding.
Now who will be the arbitrator here?
Oh, arbitrator, my lord, that is different aspect. My lord.
You go to arbitration. It has to go to arbitration then.
No, you can't. You're beyond the time. And you have not challenged. You say because he appeared 13 months later,
Yes.
so the DRB recommendation will not be, the time limit frames given will not be binding. How can that be? You participated therein. So you waived the whatever delay was there on the part of the petitioner?
Only simply that we have, my lord, participated. It doesn't mean that, my lord,
Where is your objection to that? Have you raised any objection before the DRB to that effect? That you are not entitled to hear this in terms of the conditions of the contract?
This part, my lord, I will get mentioned.
What? Where is there it in your affidavit? This should be in your affidavit.
My lord, this affidavit was taken 2019.
These affidavits have been filed after the proceeding here. Then
Yes. But my lord, it will be there in the record, my lord. Yes.
18 matter.
18 matter.
7 years only.
This is the first thing you should have highlighted before this court. That this is the objection we have taken before the DRB. DRB did not. Now you'll have to comply with DRB. 12/7/27. Strictly in terms of the agreement there.
Is what, my lord, whether we have raised or not, my lord, that part, my lord, we have.
Can't help it. You have not even challenged that. And you referred it to arbitration. What were the follow-up steps you have taken? What follow-up steps did you take after the issuance of that notification, that communication?
That I can speak, my lord.
Nothing.
That has to be there, Mr. Dhar, in your affidavit at the first instance.
Affidavit 2000.
Be that as it may, fresh affidavit at that point of time.
What happened after that, my lord? I can.
No, where is that 1310? Huh? Refer the matter to arbitration on 13/10/2017. This is a decision. When did you actually refer the matter? Because you have filed this affidavit in 2019. So there is nothing here that you have actually referred the matter. This is a decision and reference is a different thing. It will require a further act. Where is that act?
That is what, my lord, I have to.
Nothing is.
Why? In your affidavit, why it is not there?
Maybe some inverted error. My lord, happens, my lord. We are all humans.
And the arbitration clause is at page 38, my lord. That is different, my lord, altogether. My lord.
No, that is different.
They have not done anything, my lord.
Just now.
We have objected.
When did you file this writ petition, Mr. Savala?
My lord,
12/6/2018.
2018.
So is there any statement in your writ petition that after 13/10/17 till 11/6/2018, there was no reference at all? Because this cannot be held to be a reference.
Yes.
Mr. Dhar. Okay.
Actually, my lord, the very first time I am seeing this file.
I also saw this first time in my life, yesterday night.
I saw, my lord, this is the second file, my lord. Actually, my friend, learned friend, he was appearing in this matter, my lord. He has some difficulty, so we'll get the instruction, my lord.
The tentative view is that the DRB recommendations have attained finality. And merely saying that, informing him that, okay, we have decided to refer, where is the reference? Mr. Saiwala, there has to be a reference to
Reference,
it.
my lord, as per 25(3), nothing has been done.
We will not put Mr. Thor to trouble. We'll give him one date. Have it next week, Kundina Pari. 8. Heard Mr. G. N. Saiwala, learned senior counsel, appearing for the petitioner, and Mr. R. Dhar, learned counsel, appearing for the standing counsel, PWD department, appearing for the respondents. So it is the contention of Mr. G. N. Saiwala that the decision of the Dispute Redressal Board was rendered on 13/7/2017, and in terms of the agreement entered into by and between the parties to the proceeding, if there is any grievance with regard to such a recommendation made by the DRB, within 28 days thereof, the matter is to be referred to the arbitrator for arbitration in terms of the provisions of section or clause 25.3 of the arbitration agreement. So, Mr. Sahiwala has submitted that the respondent authorities in the PW department, via a communication dated 13/10/2017, had intimated the petitioner of its decision to refer the matter to arbitration. So, however, he has submitted that thereafter there is no material brought on record. There is no material available to indicate that the matter was actually referred to arbitrator, inasmuch as no notice has been received from the arbitrator by the petitioner in the matter. Posed with the above situation, Mr. Thar submits that the affidavit filed by the respondent authorities having not brought on record any material in this connection, he be granted a week's time to complete his instructions in the matter. This court reluctantly, in view of the affidavit filed, in view of the fact that no such in this court reluctantly accepts the submissions made by Mr. R. Dhar and permits him time till 8/8/2025 to complete his instructions. No further adjournment shall be granted in the matter to either of the parties. Registry to list this matter again on 8/8/25 for further hearing. Just get me that information, reference which date you made. Mr. Sarfa, your next matter. 25th, this matter only. Reason to believe. Yes. Yes, Mr. Chetia.
No.
You have filed a detailed affidavit, but where is the material? Some information was received.
There are Lordship 9 of our affidavit, running page 154, my lord.
Mr. Saraf, now that you are appearing, what is the law here?
The regions which are there, the belief must have a live connection with the regions. And the regions cannot be vague. Regions must be specific. And not for the making of an inquiry, some has been received concrete that income has escaped assessment, then he can proceed. Now, in this case, my lord, admittedly they are saying that due to paucity of time, we have not been able to make
Any inquiry.
detailed inquiry. Now, if you have not been able to make detailed inquiry, how you can issue the 148 notice?
And they say something about informations received also.
Information may be anything. Information they may say there's some information is there. What information is there? That must be on the regions. Now they are saying about long-term capital gain that was disclosed in the return.
Because some shares were sold by you and that
Has been duly shown in the return. You're also see the long-term.
you say in the initial notice, somewhere I've seen that there was no reason assigned in the initial notice given to you.
Initial notice was given wrongly. Some other regions were forwarded to me.
Huh.
So I said then they are given fresh notice.
Then they gave you a withdrew that and gave you a fresh notice. So in between the initial notice and the fresh notice,
My lord.
whether the reasons given in the second, we can go to the first notice first.
Let me just see, my lord, page 39. The computation at the bottom, my lord.
Long-term capital gain.
Amount so and so.
Huh.
So this was duly reflected in the
Return.
in the return. Now, the reopening can be done when something is not available. When something was very much available in the return, and the long-term capital paid 57 million. You'll also see the
You can come to page 51 also, wherein the breakup has been given.
All names.
Breakup has been
was given. It's not so that the name of the parties, everything was given. Now, you'll also see the page, the regions which have been given. Page 96. Page 96.
No, the first notice is page 58.
I'll take you also the page 56 also. You'll also
98.
96.
96.
Recording of satisfaction. And you'll also see page 97, para 5. The beneficiary sells these shares in a very short span and long-term capital gain was booked accordingly. As the shares are acquired through off-market transaction, it will not reflected in the trade so-and-so script acquired from the stock exchange. Hence, in such cases, such beneficiaries by quantity of the period will be either such lower than the share quantity of it. Due to positive time, such transactions could not be identified for each beneficiary. Now, beneficiary was myself. Now, this is the general trend that it is sold. He's saying that this is in this way it is sold. Very correct. But who are the beneficiaries? They say that we have not been able to identify who is the beneficiary.
Where is your corresponding statement to this in the writ petition?
My lord.
Your corresponding statement to this?
My lord.
Para 23.
My lord. My lord. This is the, my lord, the legal submissions, my lord. And factually, my lord, I have submitted.
Factual submission is that page?
Para? Your Lordship, in para 11, your Lordship, first see. The receipt of the said letter, the principal prisoner submitted his objection to the reasons recorded, while objection letter so and so. In the said objection, the petitioner raised various contentions against the reopening of the assessment under the purported exercise of powers under Section 148 of the Income Tax Act for the assessment year so and so. The petitioner in the said objection submitted the assessing authority recorded the reasons on 31/3/2021, which was recommended by the range head on the same date and has been approved by the Principal Commissioner of Income Tax on the same date without application of mine, and thereby it can be assumed that the sanction granted by the Principal Commissioner of Income Tax was only a mechanical sanction without due application of mine. The petitioner further submitted that if the said objection that since the total income of the petitioner as per the return of total income was so and so, the case of the petitioner could not have been reopened by the Assistant Commissioner of Income Tax inasmuch as, in view of the CVT circular, as well as the jurisdictional bifurcation of the Principal Commissioner of Income Tax, the jurisdiction lies with the income tax officer only, and in case of having income above 15 lakhs, the jurisdiction lies with the Assistant Commissioner of Tax. That in the said objection, the petitioner certainly submitted with regard to the allegation that the petitioner received a sum of rupees so and so from so and so, but in fact the petitioner received a sum of rupees from so and so, and thereby no proper inquiry was made for issuance of notice in the so and so. Now they are saying that I received this amount from a particular party.
But they say they have not inquired into it.
Now this was not the party at all.
Okay.
You'll also see allegation the petitioner received a sum of rupees from Luke's Health Services Limited, but in fact the petitioner received a sum of rupees
Higher sum.
from, and no proper inquiry was made for issuance of notice number 148 of Income Tax Act, as well as the assessing officer recorded wrong facts while recording the regions in the notice under Section 148 of Income Tax Act. The petitioner further submit that in paragraph 3 of the regions recorded was not relevant at all, in line with the law itself provided by the method in which the off-market purchases are made, and there was no reason for not accepting the same by the assessing authority. With regard to the paragraph 4 and 5 of the regions recorded by the assessing officer, it is submitted that no evidence with regard to the convenience of the operator has been brought on record. The petitioner further submitted paragraph 5 of the regions recorded clearly shows the notice in the so-and-so was issued in a mechanical manner without making proper inquiry. As in the said paragraph, it has been stated that due to paucity of time, transactions could not be identified for such beneficiary. The petitioner further submitted reply the assessing officer recorded conclusion with regard to certain off-market transactions and booking of long-term capital gain, short-term capital gain, which is not related to the petitioner. The petitioner submitted there was no predetermined conclusion without making an inquiry and bringing so-and-so, so-and-so.
So you have got no transaction with Luke Health.
No.
But you have brought this from Vineet and sold it to IGC.
Now, these transactions, the system which is showing, that is not illegal. What he is
Off-market purchases.
Off-market purchases. if the off-market purchases would not have been permissible at all, then I can understand. Off-market purchases are permissible. Now, if you find that these are bogus, then you have to, you know,
Bring
give
on
the facts
record
and
material.
reasons that how they are bogus.
So that is your case.
Yes, sir.
That while recording para 5,
Still also, Your Lordship, the petitioner further submitted that the petitioner was not engaged in short-term selling from looks in so-and-so limited, and the petitioner never purchased from the said concern nor had sold the shares to the same. The petitioner purchased the so-and-so and supported the same. The petitioner attached the contact notes, etc. The petitioner further submitted that the assessing authority recorded that the bogus accommodation of long-term capital gains, short-term capital gains. Now you're asking, see, long-term capital gain and short-term capital gain. Well, either it has to be long-term capital gain.
because here they say it's long term, but what you have done, they allege is that you brought it, immediately sold it. So it will be a short term.
Short-term. So he's saying long-term oblique short-term. The nature of transactions were not known to the assessing officer at the time of recording of the regions that the petitioner booked long-term capital gain or had booked short-term capital gain. The petitioner submitted the petitioner had disclosed a sum of rupees 35 lakhs so-and-so on account of long-term capital gain, which was exempted in the Income Tax Act so-and-so, so-and-so. Now,
Have they brought on record in the notice the period when you brought these shares and when you had sold these shares?
he has only given a chart and all those things, the system and all those things.
Where?
The last and in the affidavit. In the order also, you'll also see at page 120, 116, it starts below. Oh, my lord, it is Annexure 10, page 113. Trading activity in Lux Health Services Limited. Now, the entire documents are on that basis. They have annexed.
Any reference to you here? Your name
No,
somewhere? No. So how is this presumption drawn that it is Look Health from whom? Because there was a scrutiny against Look Health. Any material to show, Mr. Chetia, any material to show with regard to your conclusion?
Sanction, that is at page lordship 96, my lord. Itself has stated, my lord, at page 97, my lord. Here it from para 1, lordship. Going so the assessee of this circle has filed its return income electronically. The total income at rupees 10 lakhs and so. As per information available in Insight portal of departmental database, it is found that Sri so-and-so was beneficiary of bogus long-term capital gain, short-term capital gain pertaining to financial year 13-14 to 18-19. During the financial year 2013-14, the relevant the assessment year 14-15, he has received an amount of.
Okay, just show from where you have drawn this conclusion. 34. 80 from Look Health.
Lordship, that is the Insight portal of departmental database, Lordship. That is the central database of the department, man. It was reflected thereon from the other SSE, Lordship. This is the centralized system, Lordship, where all the particulars pertain to the SSE is there, my lord. So, my lord, here the question is, my lord, it is only the notice, my lord. Notice issued under section 148, my lord. And still, my lord, no final order has been passed, my lord.
Has he filed a reply to that? No.
Yes, he filed a reply.
So what is this stand yours against 2, Mr. Saraf?
Which fellow?
Para 2 in page 97.
Page 97.
So that reason to believe there is some material now. They say Insight portal of departmental database.
Fellow.
From where they have found transactions between you and Look Health. Although you have denied it.
My lord, the question, the transaction, they have justified also that how it is looks in the not there. Transaction, I have also shown that this is the long-term capital gain. There is no dispute about it. Your lordship may see that.
No, I'm not on that. I'm not on that. I am on the, you say you never had a transaction with Look Health Services. in your writ petition. But here in the notice, they say that see from the departmental database, long term, short term, we'll leave it. But you had a transaction with Look Health Services, which was being inquired into.
I will show you. What happened? These shares were earlier known as something else. You'll also see page 106. I may read paragraph C, my lord. You have stated in your objection that you have not received any amount from so-and-so. You have stated that you have received a sum of rupees so-and-so from broker message so-and-so, and that you have purchased the shares from Vinith Enterprises. It is personally mentioned in the script code with your have traded and mentioned in the regions recorded is so-and-so is in the name of Lux Health Services Limited, which was previously known as Monarch Health Services Limited. Further, your submission clearly says that you have traded shares of script of Monarch Health Services Limited, which is now known as Look Health Services Limited.
So it's basically not a transaction with Look Health Services, but the share of Look Health Services.
Earlier, when it was traded, it was not Look Health Services.
It was Monarch.
Monarch.
Mr. Saraf, the trading is with regard to the script or the company?
The question is that when you find out that you have these shares you have purchased and these are bogus.
No. It's shares of Monarch Health Services or shares purchased from Monarch Health Services?
No, it was purchased the shares of so-and-so.
That company shares, scripts.
Okay. Now we'll also see further, my lord. Two, my lord. In respect to the script, so-and-so, the script, it is seen that the financials of the script are bad and company is not having very sound financial base and do not justify investment. Now, my lord, he's saying that no, that company which was there, that was not a sound financial health and do not justify the investment. Thereafter, also we see further, it is also seen that a part of the price of the script has been rigged. Then it is further seen that parties who have ever acted in existence so-and-so are so-and-so. Now, my lord, there are various Supreme Court judgments also. I'll show to you also, my lord, that wherein it was said, a party said that I used to deal in the accommodation entries. Only I used to give check and take commission and cash back total. Now, on that basis, the 148 notice was issued. The Supreme Court said that no, you have not said that this particular one, he has whatever he received is bogus. You have not said. And since you have not come to that conclusion, and thereby 148 notice cannot be issued. So 148, a person, third person, my lord, who is providing the loan and all those things, she says that, my lord, I am not providing, I am bogus. I simply used to provide the entries and take commission. Now, that person, I also received the loan, other persons also received loan. On that basis, the 148 notice was issued, and Supreme Court said that no, you cannot issue the 148 notice unless and until you arrive at a conclusion that the amount which was received by me was bogus.
Okay.
148 does not empower authorities to make inquiries.
So for my understanding, means the person who was giving the loan is a paper transactor, and you also did not receive any money other than a paper transaction only. Is that what you mean to say? Then
I'm saying that person who was giving, he was not giving to me only, he was giving to 200 persons. Now he said I was a paper transaction, I was doing all those things. But the amount which I received was a paper transaction, that finding has to be arrived at.
Okay.
Simply on that basis.
You cannot say.
You cannot.
So you mean to say, because the script of Monarch was bad, you traded in that, that will not make you liable for this.
I give an example, a matter came up for this on the court. Where a company purchased cow dung.
Please don't mind my questions. It may be nonsensical. I'm trying to understand.
But company purchased cow dung, my lord, of lakhs of rupees for the tea garden. Now, a survey and raid was conducted at his place, the person from whom he purchased. He said that I've not supplied. That person has supplied. A raid was conducted to that person, and he said that I never used to supply anything. I only used to give the accommodation entries. I used to raise the bills and take cash back and commission. On that basis, 148 notice was issued to me. That was challenged before this honorable court. And this honorable court, on the basis of the judgment which I referred to earlier, Chugmal's case, came to the conclusion, no. He has said that I used to give accommodation entries. That does not mean that whatever was supplied to him
is wrong.
Was wrong. Now, on that basis, 148 notice was quashed. Appeal was preferred by the union, that was dismissed. The matter was carried to the Supreme Court, that was also dismissed. 148 notice.
The transaction at your end has to be established or doubted with materials to be bogus.
It has to be specific. 148 notice is not for making inquiries.
It's a proceeding starting.
It's proceeding starting, reopening that region to believe that income has escaped assessment. You say that no, I make inquiry and thereafter come to the conclusion that income has escaped assessment. That is not permissible under 148. Otherwise, in all the assessments, whatever are there,
they can do anything.
They can again start inquiring.
Okay.
Also, you may see the judgment, which I was referring to at page paragraph 4. Paragraph 4, in his report, the Income Tax Office does not set out any reason for coming to the conclusion this is a fit case for issue of notice under Section 148. The material that he has before him for issuing notice under Section 148 is not mentioned in the report. In his report, he vaguely refers to certain communications received from CIT Bihar and Odisha. He does not mention the facts contained in those communications. All that he said is that these communications, it appears that these persons, elect creditors, are name lenders and the transactions are bogus. He has not come to the prima facie conclusion that the transactions to which he referred to are not genuine transactions. He appears to have only a vague feeling that there may be bogus transactions. Such a conclusion does not fulfill the requirements of Section 151(2). What the provision requires is that he must give reasons for issuance of notice under 148. In other words, he must have some prima facie grounds before him for taking action under Section 148. Further, the report mentions, hence proper investigation regarding the loan is necessary. In these words, he concluded with that there is a case for investigating to the truth of the elect transaction. This is not the same thing as saying that there are reasons to issue notice under Section 148.
So in your case, that the absence of a regular inquiry, it cannot be said that the reasons to believe is from a detailed material coming on record.
You cannot, after issuance of 148, say that no, I will make an inquiry. And he himself said, my lord, that due to paucity of time,
the next line, before issuing a notice under 140, must have either reasons to believe that by reasons of omission or failure on the part to make a return under so-and-so, so-and-so, or to disclose so-and-so, 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 alternatively,
the material facts I have disclosed.
Now, the materials were before him. He was to take a recall on that, which he has not done. And it's only because the look good company was under some scrutiny, having found that you have also transcribed.
He's saying a general thing that generally in the off market it happens like this. It may happen. Many things happens.
Where is that being brought to your case?
In my case, that yes, your whatever was there, that is bogus. I will also see the sanction which was granted in the last paragraph, my lord, about 5 or 6 lines. It's up to the question number 8.
Page?
It's the same page, next page, 657. Judgment, my lord, judgment.
Para?
Para 4, last
Last part.
my lord, the 8 or 10 lines to the question number 8.
Question number 8.
To the question number 8, it is the report which reads whether the commissioner is satisfied that it is a fit case for issuance of notice under section 148. He just noted the word yes and affixed his signature here. We are the opinion that he has read the report carefully. He could never have come to the conclusion on the matters before him that this is a fit case for issuance of section 148. The important safeguards in section 141 or 47 were lightly treated by the income tax officer or the commissioner. Both of them appear to have taken their duty imposed of them in these provisions little importance. They have substituted in the form of substance. Now on 31st, the regions were recorded. 31st, it was recommended by the authority. 31st, the commissioner gives the sanction, and the sanction, you also may see, please. 97. It was a sanction. 96. At the bottom.
Approval. This is the sanction given.
This is sanction. Can it be said, my lord, that the approval of the application of the mine?
Principal Chief Income Tax Officer.
My lord. On 31st, you give it. 31st is what recommended. 31st is simply in a mechanical way. On the reasons recorded, I am satisfied. What satisfaction is there? And 151, my lord, is an important provision that the sanction, because in all cases, my lord, the sanction is not granted. Commissioner must apply whether it is a fit case or not. He has not applied his mind at all.
This approval is under 161, 151.
151.
Okay. Anything more, Mr. Surf?
So this is there are various judgments, but
You can give me a compilation
I will give a compilation
with a small note.
and also a small note, my lord.
Yes, Mr. Chutia.
Otherwise, in all cases, my lord, the department will issue 148 to make an inquiry. The limitation and all those things will have no meaning.
Yes.
This sanction is concerned, Lordship, that is proposal, my lord, which was sent, my lord, that has to be sanctioned after satisfaction by the, my lord, principal commissioner or commissioner. Lordship, that proposal was, my lord, very detailed, prescribed, my lord, it is starting from the next phase 97. It is that the detailed proposal, everything was there, my lord.
But it also had the last line of para 5. Why did it accept escape notice of the approving authority?
My lord, all details, my lord.
No, para 5, last line.
Of this judgment, lord.
No, of page 98.
Beneficiaries by
Due to paucity of time,
Well,
such
well,
transactions.
yes,
So
yes, Lord.
he has for each beneficiary. Beneficiary means of each beneficiary trading in that trade.
Okay.
Where is the connection to that with the petitioner?
My lord, that everything, my lord, that is not possible because of the time, my lord, it was already mentioned, lordship. Because it is a time constraint, my lord, the assessment has to be, notice has to be issued within a particular period of time. That is 4 years, my lord, and from 4 to 6 years, my lord, with the sanction of the, my lord, commissioner, my lord.
Mr. Chatia, if I just may ask you one question. We have a FIR filed.
Okay.
Investigation is concluded, and then a charge sheet is filed. And then the charge is framed. Then we have a trial.
Lord.
It's a different thing altogether. Now, here is it the provision that 148 is in the form of a charge sheet. You can't have an investigation after a charge sheet. You can have a trial.
My lord, here, lordship, the 147, my lord, that is reopening of assessment law. That is upon the compliance of the provision that the assessing authority must have a reason to believe that the escaped assessment, certain amount has been escaped assessment, my lord. And that has to be.
Because see, he has given in his return, he has clearly mentioned that this is my long-term gain, capital gain.
My lord, that has been, my lord, disputed, my lord, in this, my lord. letter,
And
lordship.
see, the long-term capital gain
Yes, lordship.
is
That-
35.
That has been disputed by 97 lordship, para 2, my lord. As per information available in inside portal of departmental database, my lord, it is clearly reflected, my lord. It is found that so-and-so was beneficiary of bogus LTCC and L pertaining to so-and-so, so-and-so, so-and-so. Directorate of Income Tax Investigation Delhi carried out an investigation on tax evasion through bogus long-term capital gain, short-term capital loss by way of manipulated trading. During the script analysis, it is observed that at many places, short selling has been done by various clients, meaning thereby that number of shares sold by the parties is greater than that over quantity brought by them over the exchange platform, which points out to the fact that various clients have undertaken off-market transaction as well. The first leg of this transaction, that is acquisition of shares, mostly is offline. This is done to save the FTT using the loophole in section 1038 of the IT Act, which places restrictions on trading by payment of STT on sales of shares and not on purchase. Further, the above scheme of rigging the price of shares of generating bogus gain loss is done in the connivance of the operator who will get the fake backdated contract notes issued to the beneficiary from one of the cartel broker and acquisition of the shares of a penny stock. The contract notes will bear the date of at least 12 months back. So to avoid the capital gain tax on LTCC, actual shares of transferred beneficiaries demat account by off-market transactions and it will not reflect in the stock market database. By that time, the operator and his cartel would have already inflated the price of these shares using circular trading. So, my lord, it has been detected by the tax evasion, my lord, the inside portal of departmental database, my lord. That is, after a detailed investigation by the, my lord, Directorate of Income Tax Investigation Delhi, my lord, it has been observed, my lord. So everything has been placed, my lord, before the commissioner, my lord, and
Now you
after
come
going
to
the
what Mr. Saraf is submitting is that 142 issue 148 notice, there has to be materials which will show satisfaction. It cannot be a doubt or an assumption.
Lord.
Now you come to page 99, para 9.
However, the beneficiary might be.
Might be.
Yeah, might be the shares through layers of transactions. Shares are claimed to have been purchased long time back. Payment of these stated might have been issued thus before the sale of the shares. The date on contract note may be fake. It is also found that the shares are found to be purchased through stock market and the possession of the shares in the hands of the beneficiary within 12 months. Then the claim of
Income tax act.
stands wrong, where the sales consideration approximately being within a few days of the actual purchase from the stock market represents unaccounted money of beneficiary assessee. It may also be noted that the pattern of shares having been acquired through off-market transfer immediately before selling the same through stock market is seen in several hundred of cases linked to the entry operators. This cannot be anything else but accommodation entry. My lord, what I am humbly submit before your lord. The authority, my lord, while issuing the notice under section 148, they need not to be a conclusive.
That is what I want to know. Just
Yes, lordship. Because some material is there, my lord. And it was a notice, my lord, giving an opportunity to the assessee to file reply, my lord. This is only a notice, my lord. No, my lord, the final order has been passed, my lord. And my lord, in this regard, my lord, I'd like to place one judgment of the Supreme Court lordship. Why 148 is required, my lord? Or that is 2008-14 SEC.
Just a moment. What is the impact of this explanation to 148A? Oh, that has come in subsequently, I suppose.
Around 9, my lord, page 7.
This is for the year, Mr. The taxes for the year, financial year, assessment year.
14,
14,
15.
15. Assessment.
So the unamended provisions would come into being. Mr. Saraf,
Hello.
if we go into the unamended provisions of 148, the reason to believe is not there.
Hello.
If I may be wrong, I may be having the wrong provision with me.
That needs to be seen.
148.2.
147 you have to see, Lordship.
Okay, let us see 147. As it stood before that. If the as, okay.
$148 is only issuance of notice.
Notice only.
147
That for that the reasons have to be allowed. But for before that 147 has to be crossed. So this reasons have to be understood in the context of 147.
Your Lordship may also, my lord, because your Lordship may also see, my lord, one paragraph of the notice which was issued to me. My lord, at page 99. Paragraph 11, my lord. On further investigation, we found that so-and-so, under jurisdiction of so-and-so, one of such entity was engaged in the short-term sale traders is hired by so-and-so, from so-and-so, with the motive of making bogus entries in the of long-term capital gain oblique short-term capital gain by trading a script of so-and-so. However, this being the unaccounted income has never been offered to tax. You'll also see that in the return. It has been duly offered, although it is exempted, what can be done? At page 39.
Okay,
and the details of the shares,
page 51.
my lord. So it's total non-application of mine, my lord.
But here, I don't find this Monarch Health is there.
My lord?
8,000. Monarch Health, 8,000.
Monarch Health, it is there, my lord.
But the appreciation is
Use
34 lakhs. Appreciation.
relax. It doesn't mean that, my lord,
Not possible.
not possible. My lord, my question is that, my lord, this is 148 proceedings.
Got it.
One may do it at the time of 143.3, somebody can do it.
Is there any time limit prescribed for a 148
My
procedure?
lord, it is 4 years, and after 4 years, if there is a failure on the part of the SSC to disclose the material facts.
And
Now,
this
where-
is within 4 years. This notice is
4 years. After 4 years. So
okay.
where is my failure to disclose the material facts?
Because you have already done it.
I have already disclosed.
This notice was issued to you on 3/3/22. Where is that provision with regard to that 4 years thing?
Like in the 147 itself. No? 147.
140. $149 time limit for notice.
Time limit.
So, no action shall be taken under this section after the expiry of 4 years from the date of the relevant assessment year. But you have not taken a point to that effect, I suppose, Mr.
Well, that is there. That there was no failure.
Now, that there was a failure to take action within 4 years.
No, but the question that will be there, that after 4 years, if there is a failure on the part of the SSC to disclose material facts, I have stated there was no failure at all.
So, what would be the purport of that term, material facts?
No, material facts for the purpose of the assessment.
Now, how do you come to that stage?
So
Because
that's the material facts which is necessary, the long-term capital gain and the shares, all these things. What more I can do?
no. Say assessing officer, within 4 years comes that there is under assessment or income or something, he can issue a notice. There is no problem. After 4 years, if a notice is to be issued, is there a further stipulation to be made that you have not disclosed the proper?
That is there. If only on failure of the SSC to disclose the material facts.
Where?
कुरान किताब आने लगी है। देखो अभी।
What if the unamended section, my lord? That was up to, my lord, 31/3/2021, my lord. It says, my lord, 149 time limit for notice.
149.
149 subsection 1, my lord. No notice under section 148 shall be issued for the relevant assessment year. A, if 4 years have elapsed from the end of the relevant assessment year, unless the cases fall under clause B or clause C. Clause B says, my lord, if 4 years, but not more than 6 years, have escaped from the end of the relevant assessment year, unless the income chargeable to tax which has escaped assessment amounts to or is likely to amount to 1 lakh rupees or more for that year. So, my lord, it
For
falls
failure.
there, my lord. Unamended section.
For failure.
No, 147 itself provides for that.
For failure.
Provided that 147 proviso, first proviso, or this section has been made for relevant, no action shall be taken under this section after the expiry of 4 years from the date end of the relevant assessment year, unless any income chargeable to tax has escaped assessment for such assessment year by reason of failure on the part of the assessee to make a return under 139 or in response so and so, or to disclose fully and truly all material facts necessary for his assessment for that year.
Now,
Page 51 is there.
Yes. I have not shown it. the details of the long-term capital gain. Because it is exempted, I have not shown it. That will amount to failure to disclose.
Disclose material.
Purpose. But the Supreme Court also said, that I have disclosed it is not necessary for me, due to my work with the assessing officer, to say that, look, examine this example, you can have to examine further. That is not my duty.
That is their duty.
That is their duty. When the assessor will say that, please, these shares are there, you examine it, whether they are genuine or not, examine it. Why?
Just for my consumption. When you submitted this 13-14 assessment year return, Monarch was a normal script. There was nothing to it, right? So your this projection of 80,000 to 33 lakhs odd profit was accepted as a long-term capital gain. But subsequently, it came into being that this whole thing is because of a manipulation in the market, this, that. And accordingly, they were of the view that this is not a long-term capital gain, but this is a short-term capital gain.
Not saying.
For my understanding.
Well, they are saying that this is not a gain at all.
Fine. For my understanding, this is a short-term capital gain. Now, if this is a short-term capital gain, it will be assessed to income. So in that view of the matter, because of the subsequent materials coming on record with the income tax authorities, wherein this exception given to you rightly is now questionable, can they issue a notice?
The short-term capital gain is that within 12 years, the things are sold.
12 months.
12 months. Now, if I have shown that it is beyond 12 months.
Okay.
But they come to know later, no, it was within 12 months. They can do it.
But they'll have to bring that material on record.
But here, that is not the issue at all.
They have not brought that.
No, that is not issue at all. They are saying that these are all bogus. Bogus means this company has inflated.
Okay.
Now, the company has inflated or what has done?
Market operation rigging.
If I was doing the genuine thing, who was rigging? Whether I was rigging,
you are making a gain.
I was not rigging. I have done it genuinely. There may be persons who were doing it by rigging it. That does not mean that my income was not genuine. Like in the case of Supreme Court, my lord, the person said I was providing income accommodation entries.
It cannot be held that the person who received it is also involved in that.
You have to say that what I received
is wrong.
Was accommodation entries.
Correct. Means your case is that for a 147 proceeding, issuance of a 148 notice, in the context of this matter, it is not enough to say that there was some bogus trading and all those things short.
Give one more example.
But it has to be said that you have done it.
Well, I'll give one more example. Recently in GST, you'll also find fake invoices. Bills are
a few cases have come on.
Not one or two. Thousands of cases are there where fake invoices were there. Can one say that it's come to notice that fake invoices and all those things were there in the person? So we will examine your also, reopen it.
Because you have taken input tax credit.
Input tax credit. Whether my also will become the fake invoice. For that, you have to come to a conclusion that yes, your case is a fake invoice. Otherwise, the entire country, they can reopen it.
Anything more, Mr. Seria?
In India, there is no dearth of the system.
You can give me a small note.
There is no dearth of the systems of evasion.
I'm sorry, I'm a bit slow in this matters. I'm just trying to understand.
Yeah, there is no dearth of the system of the evasion.
There is.
But that doesn't mean that every person
will be
the middle of the.
No, even if the person is doing it, you will have to allege that specifically against.
In the Parsuram Potteries, in 101 ITR, the Supreme Court said, the persons who are interested with the task of implementing the tax laws must know the law first. And if they don't know the law, the revenue must suffer. If they don't know how to exercise the powers under Section 148, which is a drastic power, then they must suffer.
When can you give me the note and the judgments?
3-4 days below.
Wednesday? Thursday? Thursday. You also give me a note. And the relevant provisions, old provisions,
The old provisions.
but don't quote it in half. Quote the section in whole.
Full below.
You need not, I'm telling you.
Also, next the judgments. Also.
Judgments also and a note.
Also,
Then if I'll just go through it once. Now I'm saddled with taxes.
No, my lord, your 4 judgments have already come. 2, we don't know the result, but the
No, 2 is also ready.
No,
It have to only, the corrections going on.
Disposed of, but 2 I have seen.
Hmm.
One is the telecommunication, which Chetia was arguing.
I don't know how it is, but I have done my,
And
what
one
I
we
could.
on section 40.
Huh.
That 2 judgments I've seen. And perfectly, my lord. And the 2 or more are coming now.
Mr. Standing in a court, at least Mr. Saraf will not say against the judge.
So, my lord, at least that I will also, because judgment at least I can say. I cannot say against the judge. But the judgment after it is released, one can certainly make a comment.
That's true.
In fact, I was.
And I must thank, I was having an apprehension with
In
this.
fact, I am preparing a commentary book in the GST, which come next month. Many judgments of the High Courts, I've said that this is wrong, including 2 judgments of this Honorable Court also.
Okay.
So that is my comments.
I must be grateful to Justice Bishnoi, because it was he who removed the fear, the approach fear in me with taxes.
No, there is nothing in the text that after all the principles are the same. It has to be applied, that's all. Highly grateful. No, Thursday I will give it.
Thursday. Heard Mr. A.K. Saraf, Learned Counsel for the Learned Senior Counsel, assisted by Mr. N.N. Dr. Learned Counsel, appearing for the petitioner. Also heard Mr. S. Chetia, Learned Counsel, appearing for the Learned Standing Counsel, Income Tax Department, appearing for the respondents. Also, the parties have been heard. However, the hearing remains inconclusive. Also, the Learned Counsel for the parties have submitted that they would submit their they would submit a written argument in the matter along with the relevant case laws relied upon by them. Also, let the said written arguments be so submitted on or before 7/8/2025. Registry to list this matter again on 8/8/2025.
Can it be on 11/8? I'll be out.
11. Okay, 11/8. You can just submit it to the, so 11 I can come prepared.
I'm grateful to Lord.
I'm learning, Mr. Saraf. That's why.
I too am learning, Lord. Everybody.
No. You are a master.
No, my lord.
26.
26 also your day. We'll have it on some other day. One is enough for
In
me
fact,
today.
this matter, my lord, you also heard it earlier also.
Oh, this one.
But in 20.
My lord, with much
Yesterday-
difficulty, the
yesterday-
case I can come only your asking to see what is the issue. Earlier also you also heard it, my lord.
For 2, 4, 5, and 6, that's one about. I've received the. Can you give us some time, so that.
Just give me a, because I've not gone through
That, my lord, there was an industrial policy of 2014. And the industrial policy of 2014, there was a remission scheme, tax remission. Now, after 2017, when the GST came, my lord, then certain items were taken out from the VAT and put in the GST. But certain items were still kept under the VAT. That were petroleum products,
petroleum production.
the liquor, and all those things were still in the VAT. After the GST came, the remission scheme was withdrawn on the ground that the GST has come and there was VAT is not there.
So, but what would have be the effect for the products already
In there, and that industrial policy has not been, my lord, any
altered?
amendment. And subsequently, the budgetary scheme came, my lord, for giving the benefits in respect of the industries who were availing the remission scheme. There also, they have given that in after that also 2014, if anybody is taking up, establish a new industry or taking the expansion, they will be entitled for the budgetary scheme. Now, I am neither in the budgetary scheme nor for the remission, I am out.
But you were covered by the remission scheme earlier.
Earlier I was covered, but I established after the remission scheme because industrial policy is there. And the budget.
So your establishment of the industry is not in terms of the remission, but in terms of the industry policy.
The remission scheme is only
Under that.
only a my lord, notification to give effect to the industrial policy resolution. And the Supreme Court also, my lord, in one of the cases has said
I remember.
that whether notification is there or not, the court cannot direct the authorities to issue the notification, but the industry will be entitled to the benefit on the ground of promissory estoppel on the basis of the policy.
Industry policy.
And in fact, the tax department also wrote to the industry department that there is some mistake. And this needs amendment because this benefit has to be given. Now they have rejected it.
That is why you are before us. Okay, Mr. Nath, when do you want it? Subject to correction, but subject to Mr. Any date you
So
can.
affidavit have been.
Everything is ready.
Pleadings is complete.
Pleadings are complete.
Pleadings are complete.
This week, my lord, if you also can fix it because
Let it be in the second week of August.
The second week would be next week.
11th,
Literally.
11th,
11th or
11, 12th.
12th.
12, ठीक है, sir, board is it. 14. As agreed to, heard the Learning Council for the parties, has agreed to by the Learning Council for the parties, the registry to list this matter again on 14/8/2025 for admission hearing.
Well, finally, well, admission at the disposal stage.
As a first up, an endeavor would be made to dispose of the matter on the next date of listing.
I prepare a short note in advance.
You can just give that if matter comes up before me, it will be very helpful for me. Both of you. Both of you. I'm sorry, this is something which I am now picking up only. Yes, Mr. Atia, how can we help you here?
They have to submit the record.
How did you make, forget it, man. How did you make that settlement? How did you make that allotment? Huh?
As the time is on left,
Who?
appearing in this matter.
Oh, call Mr. Esther. Let Mr. Esther. Your only case is 105. Notice, if they can show that they have done it in a manner known to law, you may not have a case.
See the my notes.
My notes, I got it. Nothing is there. Nothing is there. 4 names have been incorporated.
Executive officer also.
Was not there. Maybe executive officer's absence may not be material if he has subsequently considered. But my issue is how that allotments were made.
Yes.
Whether that is in a manner known to law.
Yes.
That much. Let Mr. Tell Mr. Just on this point, he can satisfy us.
31.
None appears for the petitioner on call. Miss. Mr. Oh, you're there. You're basically a subcontractor.
Subcontractor.
Remember the arguments you make when you have been appearing from this side. Huh?
Your Lordship, only I
Ah.
only placed this on section 70 of the
Ah.
Contempt Act, Your Lordship.
The promptings that you had made when you appear from this side.
Yes, Your Lordship.
So I am applying those promptings now in this matter. Whether you will go before the civil court.
Yes, Your Lordship. The thing is, Your Lordship, I place reliance on only section 70. And also
70.
the conduct.
Okay, 70 is one thing. Who is the main contractor here? You. Why have you not paid the money? Oh, be that as it may, you have entered into a subcontract with him, you have not paid him the money.
Not decided.
That he has got no headache. That is between you and madam. You decide. But his thing, he'll have to pay. I think you go before the section 70, I don't think so will come.
The thing is, Your Lordship, they have given undertaking to that effect. That NHIDCL
undertaking is for
may
a
pay
period.
directly to me.
Undertaking is for a period. And even if after that also you have raised bills.
No, not.
That is the specific
not
plea in the affidavit.
That is what I am.
70 cannot.
I have
I have my reservations.
actually denied that in my rejoinder, Your Lordship.
See, here the contract is between you two. He is very much here. You go before the civil court established, get the money.
Not
Decree.
civil court, your lordship. Since I am an MSME unit, then I'll have to actually proceed under the MSME Act.
That will be
But
more beneficial to you.
beneficial. I agree. But at the same time, your lordship, the only thing, because they
Section
have actually,
17, let us not,
NHIDCL has actually taken benefit out of it.
the benefit, the contract says, the agreement says NHIDCL is not responsible for any.
But then again.
And I remember this clearly because of Mr. D. Bora, when I was that side.
But at the same time, your lordship, only place reliance on certain judgments or on the Supreme Court.
Okay, we'll hear you.
Yes, on some
When?
given day, your
When?
lordship. Any Tuesday, Thursday, any Tuesday.
Not before 28. 28 or board only.
Does the
28.
interim order late? That may.
But the London Council for the parties, as agreed to by the London Council for the parties, Registry to list this matter again on 28/8/2025 for admission hearing. Who's up? The London Council for the petitioner shall address this court as with regards the maintainability of the present writ petition. He's having a good smile. There is no dispute. No dispute.
No
The
dispute.
money you have to pay. Let him say, let me see whether what he prompted to me when I was that side is what he's going to, or he's going to give me a different picture. I only want to see that. What was that name of that case? What happened to that actually? Mr. S.P. Roy was appearing.
Your lordship, which matter I have actually.
That is also NHIDCL. Mr. R.K. Talgda will know.
Yes, you might.
Yes, Lordship is on next.
Okay. Okay. Just inquire from him also.
Highly appreciated.
32.
Yes, Mr. Chaudhary, what has happened?
I have done.
Is he coming in?
No.
Why?
Lordship, the marks that has been subjected in the writ petition, that was with respect of the written test. Thereafter, the computer test was held, wherein he missed the bus by 1 month. I have given the last selected candidate mark for the Lordship.
You will have to give him a copy of this.
Only I will be allowed to file if my land.
So, Kishan, never have this apprehension that every case I want to finish it up. That is selected. It's not general. Okay. Okay. You come to the annexure. Somewhere you have brought a marks.
Yes, Lordship.
Where is that?
Annexure 38, Lordship. Sorry,
Okay.
Annexure 14, page 38. I have filed RTI. And through RTI reply.
Page 39.
Yes, page 39, Lordship.
That is only written marks.
Yes, but Lordship, the RTI.
And tell me one thing. Why did the petitioner not bring on record that marks? Because that is also available in the website.
This marks was petitioner has obtained this marks through an RTI.
No, it will be in the website. It will be in the website. But. Okay, page 44 is the cutoff marks for the return to interview.
Yes, sir. Yes, Lordship. Written, Lordship.
Oh, this is not the final cutoff marks.
This is not the. Lordship, I have filed on in the top.
That I missed out. I was under the impression that this is the final cutoff marks. Mr. Krishna Traya. Gone. I was there with you till the last date. That is the problem with Mr. Chaudhary. He enters, you are bulldozed.
One opportunity may be given, Lordship. Let me.
I'm doing nothing. I'm
Lord-
keeping it. You have your satisfaction. Give him a copy.
Yes.
Mr. B. Chaudhary, learned counsel for the petitioner, has placed on record the marks scored by the last candidate appointed against OBC quota in the recruitment in question in the present proceedings. Also, it is seen that the said candidate had obtained 140.50 marks. Also, the petitioner, on the other hand, in the said recruitment process, after completion of all stages of the same, could secure only 139.50 marks. Also, the contention made by the petitioner in the present proceedings that he having secured 115 and the cutoff marks being 111 for the OBC category, he was required to be appointed against one of the posts earmarked for the OBC community candidate, would not mandate acceptance inasmuch as the said marks projected by the petitioner is only for one of the segments of the selection process, that is the written examination. The petitioner had not brought on record in the petition the marks scored by him in the further stages of the selection process, which has now been placed on record by Mr. B. Chaudhary. However, for the ends of justice, Mr. S. N. Krishnatraya is granted, learned counsel for the petitioner is granted a week's time to complete his instructions in the matter. Also, Registry to list this matter again on 12/8. No.
So can it be
What is
after,
it?
after 15th,
Huh?
Lordship, if possible?
ठीक है, 12.
Lordship, can it be
Baro?
after,
13, 8,
Lordship,
10.
Lordship, can it be after 15th, Lordship, if possible?
Why?
Lordship, on 13, Lordship, I have some.
Okay,
matters
okay, no problem.
at
No problem.
null
No
by
problem.
Lordship.
On 19, on 19/8/2025 for further hearing. The instructions furnished by instructions received by Mr. B. Chaudhary and furnished before this court is kept on record and marked as X.
Liberty, if anything to.
Anything you bring on record, we will get hold of Mr. Chaudhary then.
Actually, Lordship, I have got the marks through an RTI, and through an RTI, I have not received the.
It's not your mistake.
Yes.
I also committed that mistake. Holding that is the final marks. No problem.
33.
Well, interim order was there.
Interim order passed earlier to continue
18th.
until further orders.
Oh, Lordship.
It pleases your lordship.
30?
33. Lordship, in this case.
Yeah, there was a partition suit and your Chitta mutation on behalf of that was cancelled. Yes.
Mutation.
What do you say? How can that be?
Because title suit was pending. That was
Title suit is pending.
regarding the same plot of land.
Fine. Is there any injunction?
No, my.
Then what happens finally has happened. This title suit is between whom? Who is the defendant there? You have filed the title suit?
Yes, yes.
Oh.
I have filed the title suit. Like all are the legal heirs of my great grandfather Nek Mahmud. They are
But they are
sons
not.
and
But they are not made parties in
Well,
this person.
basically all the stakeholders of the land are made party.
In
They are
the-
defendants. Yes, Lord. In the partition suit, my lord.
Okay, we hear it now. Affidavits have come.
Yes, Lord.
Like they said that the pleading in the matter is complete. Accordingly, registry to list. You have an interim direction?
No,
No.
my lord.
Registry to list this matter again in the last week of August 2025 for admission hearing on a date to be fixed by it. Last week we will put it.
All right.
36, 37, 38, 36, 37, right? Two matters. I can't. None, not not before midday.
Today, Lordship, yeah.
36, 37. Huh?
Today, Lordship.
Can. These matters are still alive. Get it? I was going through the brief. I'm just going. Facts were so familiar. Then I started looking for judgments. Then I found bold letters. Kiman? Next to Madam or Customer. Yes, Mr. Soma.
My lord,
Certificate by an arbiter. There is a decision, Tinsukia, with regard to yours is what number?
38.
No. The off license is with regard to which shop number? Shop number?
The tender, madam.
IMFL retail shop. That's what I say. Mr. Goswami, that much the reading we do. This is just get hold of a judgment with regard to shop number 10. My Lord Justice Michael Jodangkumar's judgment, and just apprise this court. Mr. You are, no, you are not. You are appearing. No, you are not appearing. Mr. Buragohai. He is also Buragohai. Deepanka Chetia, there is one more.
Deepanka was part of Honorable Justice Michael Jodangkumar. I guess regarding this, I most probably say conversion, I guess.
No, not conversion. This is tender, same tender. This is TSK 1. That was TSK 10.
TSK 10.
Just get that judgment. It covers this matter. Can you?
They have also filed an affidavit yesterday. It has not been.
You file a reply,
file
but that will be relevant. You take the number from Mr. Google. Mr. R. Hajorika, Learned Senior Counsel, appearing for the heard Mr. R. Hajorika, R. Sharma, Learned Senior Counsel, appearing for the petitioner, assisted by Ms. P. Fukan. Also heard Mr. N. Goswami, Learned Government Advocate, appearing for the respondents. Ms. P. Fukan, Learned Counsel, appearing for the petitioner, submits that she be granted 2 weeks' time to file an affidavit on behalf of a rejoinder affidavit on behalf of the petitioner against the affidavit filed by the respondents. Registry to list this matter immediately after 2 weeks, along with the affidavit filed by the respondents as well as the affidavit in reply, now undertaken to be brought on record before the next date of listing by the petitioner.
Interim orders.
Interim order, if interim order passes earlier, to continue till the next date of listing. Yes, madam, come.
Apply.
The statement which I made, I did not put a direct statement, but I have talked to my client. They had already done this process. They let me have 1 single day to submit that. They have done. Lordship. Because
that should have been here.
Yes, it's my mistake, Lordship. Lordship, what
It's not your mistake. This is not your
because
creation.
No, Lordship.
This is not your creation, this petition. Have you drafted it?
My junior did it, but that time I was in a, Lordship knows my period. So my junior did it, but this is, I already told you, Lordship, first. It's a very, very poorly drafted petition.
But madam, this cannot be accepted.
Lordship, they had.
Fine, even if you demonstrate that they had done
Yes.
that approval, that the state cannot be permitted to waive. Now, what we propose is, subject to what you say, you agree to this, that we are not going ahead with the tender process. I'll have the tender process. What happened after this tender process? Nothing?
Nothing.
Nothing? State, we quashed that. We require the state government to take a call whether they want to put this for further query to tender. If they agree, if they decide, yes, they will apply. You are also free to apply.
Lordship. Even because there's so much of public money involved here, and this is a.
I don't think so, madam.
Yes, Lordship, I understand that.
After 14, if it was a matter immediate, then we could have taken a call. And you also see these are dealt with now by the minor mineral
Concession rules.
concession rules. And that's very strict.
I've gone.
That's very strict. Okay, I'm not passing, I'm just recording a concession from both sides. We'll interfere with that. Heard Ms. S.P. Hussain, learned counsel for the petitioner, and Mr. R. Gogoi, learned counsel appearing for the standing counsel Forest Department, appearing for the respondents. State respond for in the above noted writ petitions. Also, none has appeared on behalf of the respondent number 6 in WPC number 1566/2020. Notices were served on him. Notices were served in spite of service of notice upon him. Also, the petitioner in the present in the above noted writ petitions, in the writ petitions involved, in the above noted writ petitions have presented a challenge to the cancellation of the cancellation is at page.
They did not cancel it, Lordship. That is what my contention is. But that they did not cancel the advertise. Only later on, Lordship, they submit a affidavit in opposition in the other petition which was withdrawn. I was the counsel there also. So this needed to be brought into record. That's why I filed this.
Okay. Have
Cancelled it.
impugned cancellation order number dated 2/1/2025, cancelling the processing for diversion
2015.
proposals
2015.
2015, cancelling the processing of the diversion proposals in reserve forest areas for stone quarries under various ranges of the Nagaon Forest Division, Nagaon, due to technical difficulties. Also, the petitioner has also challenged advertisement dated 17/3/2017, by which the Mahal, part of the Mahal, by which the Mahal, part of which was settled with her in an earlier round of bidding process. Also, the learned counsel for the parties have at the outset submitted that in view of the long lapse of time passing in the matter after issuance of the advertisement dated 17/3/2017 and the public interest involved and the Mahal being not permissible today to be settled at the rates so quoted in the said notice, in the said tender, and further, the said tender process having been kept in abeyance by this court, wide order dated 4/12/2019 in IA bracketed C number 4129/2019, this court would be called upon to interfere with the said tender process insofar as it concerns Beldenga Stone Mahal number 1. Also, this court appreciates the submissions made by the learned counsel for the parties and also notices that the said stone quarry being Beldenga Stone Mahal number 1 has remained inoperative since 2014 when it was put to tender and the petitioner was selected for submission of diversion proposals therein, which has not been taken to its logical conclusion till date. Also, in view of the above, in view of the above, this court is of the considered view that the short tender notice dated 17/3/2017, insofar as it concerned Beldenga Stone Mahal number 1, cannot be sustained, and accordingly the same stands set aside. Also, having interfered with the said short tender notice insofar as it concerned Beldenga Stone Mahal number 1, comma, the authorities in the Forest Department are now directed to take a decision as to whether the said mahal is required to be put up for tender, and if the decision is so taken for putting up the mahal on tender, this same be so settled strictly following the provisions of law governing the field. Also, the petitioner herein shall also be permitted to participate in such tender process, provided he fulfills the eligibility criteria so set out. So, earnest money.
Earnest money, they can approach a lot.
This court having interfered with the tender dated 17/3/2017, but having not interfered with the cancellation of the settlement made with the petitioner, comma, the petitioner would be entitled to the earnest money and security deposit. You have not given earnest money.
Yeah,
Earnest money deposited by her in pursuance to the earlier tender process initiated by the notice inviting quotations dated 7/2/2024. The petitioner would now file an application before the Principal Chief Conservator of Forest and Head of Forest Force Assam, staking a claim for being refunded the earnest money deposited by her. Also, the Principal Chief Conservator of Forest and Head of Forest Force Assam, comma, shall, on such application being submitted by the petitioner. Why was that amount not released to her?
Because Lordship, if I may take to this petition 156/2020, whereby page 55, they were asked to take the earnest money allotment. Is it not?
No, Lordship, that is
It's the same notice.
Money.
Lordship, I'll just point out this Lordship will come to 55. It's a very, if Lordship is satisfied, Lordship will see this was a manufactured document which I have stated in my petition. This was done because of one file.
Yes, 2/1/2.
Yes. This one 2/1/15. This is the content. Because that's Lordship will see at 6 notice board.
There. Submit an application before the so and so. Stake a claim for being refunded the earnest money deposited in the matter, along with interest at bank norms. Also, the PCCF head of Forest Force, on receipt of such a representation from the petitioner, shall schedule a date of hearing in the matter, and thereafter, after hearing the petitioner and also permitting the petitioner to adduce evidence as may be required, and also hearing the concerned divisional forest authorities, comma, proceed to decide the claim made by the petitioner in the matter and pass a speaking order in this connection. Also, in the event the petitioner is successful in demonstrating before the PCCF head of Forest Force that the earnest money was never offered to be refunded to the petitioner, comma, the Principal Chief Conservator of Forest and Head of Forest Force shall, in his speaking order, provide for refund of such money along with interest at bank norms thereof. Anything more required? With the above observations and directions, the above noted writ petitions stand disposed of. No further order is come. Just modify the order bit. You will have it on Monday. The order, you'll get it on Monday. Because today we will be not here after 4. There is a 8 hours, মানে এটা কিমানটা আছে না না ইয়াত এতিয়া আমি এটা কোনটো কৰিলো না এটা কোনটোলে কৰিলো আমি 38 এইকেইটা শেষ কৰি দিওঁ we'll finish up the orders if not inconvenient to all. Yes, Mr. Doctor, we'll have here at 2 o'clock. We'll have to hear this at 2 o'clock. Huh? 41. নহ'লে দুটাতে শুনিম দুটা দিগদাৰী হ'ব চবৰে we'll have it at 2 will not trouble you at 2 43
Orders.
43 orders হ'ব
This is for the service of notices for 1 and 5. I pray for service by paper publication, Milord, since it is twice I have taken.
but you have not taken Dasti.
Because it is from Haryana.
I don't know the papers which will be having wide circulation there.
No, Times of India is published from Gurgaon itself. The address is Gurgaon.
Have you taken, was notices issued through the jurisdictional court there?
That was not done. I think that will be convenient
Because the address is also not here. You have not even furnished the correct addresses for respond number 1 and 5.
I have taken addresses from their own documents, Milord.
One is
Director General of Industries and Commerce, Haryana.
but how can a state of Haryana be represented by an additional director? It should be by the
Chief Secretary itself.
or secretary or somebody like that. And respondent number 5, the note is that the address is not there.
Address is there, Milord, 5.
No, he is not found in that address. That is the note.
That I found. That I
So,
found.
so I think you will have to amend the name of the parties.
I'll refer here also. Cost title also.
Huh.
Amendment of the cost title.
Huh. And the address.
And the
Address of respondent number 5.
Okay.
Office was closed long time ago. Or you will have to file an application for deletion, I don't know.
He's the main man, Milord.
He's the main
main person. So by amendment of the cost title, Milord, I will put the name of the proprietor also in the address of the firm's name.
Mr. Des Chalia, learned counsel for the petitioner, assisted by Ms. M. Roy, learned counsel appearing for the petitioner. Also, Ms. M. Roy, learned counsel appearing for the petitioner, submits that she be granted 2 weeks' time to file an application for correction of the cost title with regard to the description of the respondent number 1 and also to provide better particulars with regard to the respondent number 5. Also, the petitioner shall file the said application on or before. How many days? 18? Within a week. Okay. On or before 12/8/2025. Registry to list this matter again on 18/8/2025 along with the said interlocutory application. Interim order. Interim order nahi hai. It's already extended.
Timing 30.
Because I have received a record, my lord.
How was that decision to allot the things taken?
The new one, my lord. Yes, ma'am. My lord, the Gao President, Gao Panchayat President and Secretary, my lord. After resolution, they have sent, my lord, minutes of the meeting, my lord. According to them, my lord.
No. How did you identify the allottees?
My lord, that was recommended by the executive committee, my lord.
No, how? How?
Yes, my lord.
How was that selection made?
Ten applications received, my lord. 5 of them, they have
10 applications received in pursuance of what?
the newly constructed. house.
Okay. How did these people come and make those applications?
Because as per the.
Was there any notice issued?
Initially, they were in that place, my lord.
I know that. But the petitioner was also there in that
It's
place.
their claim, but in the records not saying so.
Be that as it may, they have brought the
Because
allotment.
we have received 10 applications.
How did you receive this application?
The-
Was there a by wide publicity given? Because this court did not require you to make the settlement with them. It only required you to give them a preference. Preference would be when you consider amongst many, everything is same, they will get a preference. That's all. But here you have not demonstrated how you have called this application.
My lord, as per the record, my lord, 10 applications were received. I don't know how those are received.
That is important. Others will have to interfere.
was-
Because you see, 10 applications and only 5 applications from persons who were holding.
Other 5, they have filed a NOC, my lord. Other 5.
We can't. This is all a pocket tender. That means you clarify.
Lordship, otherwise, Lordship, newly, the Anchalik Panchayat newly formed, my lord. Very recently. Lordship may remand back the matter, my lord.
No,
To
no,
identify,
no identification.
otherwise, earlier committee now not available.
Fine, but how was the settlement made? That's what we want to know.
Or if Lordship.
How
may
did
also
these
direct-
10 applications come before you?
Lordship may also direct.
No, Mr. Doctor, I want to know how these 10 applications came before you.
The only records available are your lordship.
That means we'll interfere with everything.
That can be, my lord. I'm not objecting.
Anybody appearing for the private respondents?
No, my lord.
Anybody appearing?
No.
You get this instruction and also notify the allottees about dependency of this case.
That may be reflected in order.
I'll do that.
Yes.
But Mr. A.J. Atia, learned counsel for the petitioner. Also heard Mr. S. Dr. Learned standing counsel. Panchayat and Rural Development Department. Also, Mr. S. Dr. Learned counsel for the petitioners has produced the records pertaining to allotment of shops in the market complex, newly constructed market complex, in the newly constructed market complex under Obzaroni Motin Bazaar. Motin Bazaar. Also under Huzai Zilla Porishad. However, from this court has perused the records. However, therefrom it is not clear as to how the applications for allotment of the shops were so made by the concerned Panchayat. Also, Mr. Dr. on the next date of listening shall apprise this court as to how the applications were invited from interested persons for allotment of the shops in question. Full stop. It is seen from the records, it is seen that the service of notice upon the respondents number 9, 10, 11, and 12, who are the allottees of the shop in the said market, were held to have been duly served. However, there is no representation on behalf of the said respondents before this court. Mr. Dr. to the Chief Executive Officer.
Zilla Parishad.
Huzai Zilla Parishad shall inform the respondents number 9, respondents number 7 and 8 only.
My lord.
My lord, may I submit one thing? There is a resolution, my lord. It's, if I go through it, my lord, there is nothing, it's saying that any notices were issued.
Get it? Because I want the
8 to 12. 8 to 12.
Respondents number 8 to 12. 7 to, is 8 to 12.
8 to 12.
8 to 12. About the pendency of this proceeding in writing. The acknowledgement of receipt of such communication by the respondents number 8 to 11 be placed before this court by Mr. Doctor on the next date of listing. Registry to list this matter again on 27 Pari, 27/8/2025. You issue a communication and download a copy of this order and get the signature copy, place it before.
My lord.
No affidavit required.
My lord.
And then
Only
just
instruction.
get a written instruction that there was no notices issued.
Yes, yes. Highly obliged.
Hmm. 40? No, we have only asked them to get a clarification. File an interlocutory application for changing the name of respondent number 1 and respondent number 5. That much only.
Respondent number 6.
HDFC
Bank.
Huh? What is your name?
P. Bora on behalf of M.
Miss P. Bora, Learned B. Bora, Learned Counsel, representing Mr. M. Smith, Learned Counsel for the respondent number 6 is present. Item number 43, ma'am. Yes.
Supplementary list 49.
My lord, the petitioner is the principal of the my lord, ITC MyFair Ladies Center for vocational training, my lord. So, my lord, your lordship may kindly peruse Annexure A at page 12, my lord.
Madam, we are not considering it today. The pleadings are complete. We'll take it up for final discussion. Heard Miss MS SB Chaudhary, Learned Counsel for the petitioner. Also heard
My lord, A. Deka appearing on behalf of Mr. SP Das.
Mr.
SP Das.
Your?
A. Deka.
Also heard Mr. A. Deka, Learned Counsel, appearing for the respondents number
3.
Respondent number 3. It is stated that the pleadings in the matter is complete. Accordingly, anybody appearing for 4? Nobody has appeared.
My lord, taken steps, my lord. On the last occasion appeared, my lord, someone appeared.
Complete.
There's newly
It's
implemented.
complete. Accordingly, registry to none appears for respondent number 4. Registry accordingly, registry steps have pleadings have been completed. Accordingly, registry to list this matter again for admission hearing in the first week of September on a date to be fixed by it.
Obliged.
Some points are left out, so I will not.
Lordship, we have filed an affidavit yesterday.
Learned counsel for the parties have prayed for further 2 weeks' time to complete their pleadings in the matter. So, prayer allowed. The learned counsel for the parties shall invariably complete their pleadings before the next date of listing. Listed to list this matter again after 2 weeks. Entry order passed earlier to continue till the next date of listing.
52. In 49, I was appearing for respondent number 2. I was here, my lord, but I just missed.
Okay, 49, Mr. R. Dhar, learned counsel for the respondent number 2 is present.
May I plead the lordship? Repetition.
No affidavit.
No affidavit. Protection is required on the last day, lordship.
No, but that's why we kept it. We wanted to have their stand.
Yes. Lordship, the land is still under the possession of the petitioner, lordship.
Petitioner?
They are continuously possessed. Now, after passing the impleadment order, lordship, they are trying to settle the land in favor of
Nobody
others.
is appearing for the. You have nothing to do here. Heard Mr. M. Khan, learned counsel for the petition. Also, no one has entered appearance. No one appears for the respondents number. 4, 5. Circle officer will also be on the BT. 6 and 7. Miss N. Miss N. Bodle, learned. Standing Counsel, Revenue and Reforms Department. Revenue Department is appearing for the respondent number 1 and 2, while Miss M. Borman, learned. Government Advocate appears for respondent number 3. Full stop. Registry is to list this matter again on 11 of decision, 12, 13, 14, 8, 2025. Full stop. In the event there is no representation on behalf of the BTC authorities on the next date of listing, this court would proceed to consider the prayer for interim relief sought for by the petitioner.
Status quo as on today, that can be lost.
53.
Mr. Dotto,
My lord.
there is an affidavit filed.
Yes, my lord. Actually, we wanted to give a
Okay,
reply to
I know that,
My lord.
but the affidavit says that you have not even participated in the.
My lord, that's the issue, my lord.
What is it?
My lord, here the challenge is of a NIT, my lord, issued by the prisons, my lord, to supply the dietary item. In the NIT, my lord, there is a clause, my lord.
Okay, but you had approached this court.
Yes.
You had approached this court. This court then gave you a liberty.
Liberty, my lord. That clause was, my lord, that
Forget the clauses. We are not in the clauses.
No.
We are, whether you have in terms of para 6 of that order submitted your bid or not.
That's why, my lord. I approached this approach before them, my lord. Lordship, may kindly have a look at the order dated 19/6/25, my lord.
I'm on that only.
Yes, my lord. Up to paragraph 5, it was okay, my lord. Last, lordship, paragraph 2, my lord, it's important, my lord.
We have got it. Why we have seen it.
Yes, my lord. Now,
So
my lord,
after this, why have you not participated?
my lord. Paragraph 6, my lord. Lordship, may kindly see. In the interim, the petitioner should be allowed to submit the tender person to the NIT dated so and so, showing that they got an average annual turnover of 3 years, that is rupees 5 crore. Well, it should be, my lord, when we got the order, my lord, I think that with all respect, my lord, it may be a mistake, my lord. Annual turnover should be below 5 crores. My lord.
Fine. Why did you not approach?
I approached with this copy, my lord. They said that your
No, not. Why did you not approach immediately for correction?
my lord, this order was passed on 19th, my lord. And the submission of on the very next day, I got the order 21, my lord. And the last date was 23, my lord.
So you could have.
Yes, my lord. That's true, my
now that you have not participated, we cannot precipitate this matter any further.
My lord. That's true, my lord. But that clause, my lord, is, I think, my lord.
That clause we would have considered in this writ petition.
Yes, my
but
lord.
now that will be only an academic exercise.
My lord. It is
because
not
the tender has, other tenders have already dropped.
Well, the tender has been dropped, the meeting has been held, and ultimately, well, they have to take a decision to go for it.
Retender.
Retender.
Okay.
Nothing
Then
becomes-
what nothing survives. Heard Mr. N.J. Dr. Learned counsel for the petitioner. Also heard Mr. H. Nath Learned senior government advocate appearing for the respondents. Also, the petitioner hearing had instituted the present proceeding being aggrieved by a clause incorporated in the NIT dated 2/6/2000 in a NIT dated 2/6/2025 issued by the respondent authorities for supply of dietary / non-dietary articles in relation to Zone 5 jails. It is for Zone 5. Zone 5 jails. Also, the petitioner had raised a grievance to the effect that it being an MSME, it was only required to have an average annual turnover for the last 3 years below 5 crores. Have an average below 5 crores. Also, however, in the NIT, such annual turnover was so stipulated. Annual turnover required to be possessed by an intending bidder was so stipulated to be rupees 11 crores average rupees 11 crores as an average for the last three financial years. This court had wide order dated 19/6/2025 permitted the petitioner to submit his tenders. However, the petitioner was not in a position to submit his tenders. Also, when the matter was taken up for consideration today, Mr. H. Nutt on instructions have submitted that the tenders received in pursuance to the NIT in question were placed before the Departmental Purchase Committee in its meeting held on 22/7/2025. However, the said committee on perusal of the bids so received had taken a decision to go for re-tendering. Accordingly, Mr. Nath submits that the grievance raised by the petitioner in the present proceeding would not require any further adjudication. Also, the petitioner would be at liberty to participate in the fresh NIT process if he fulfills the requisite criteria therein. Also, in view of the above submissions made by Mr. H. Nath and not opposed to by Mr. N.J. Doctor, learned counsel for the petition, this court is of the considered view that no live issue arises for consideration in the represented petition, and accordingly, the writ petition stands closed. However, it is provided that in the event there is a fresh process, there is a fresh NIT issued in the matter, the petitioner would be at liberty to participate in the same, provided he fulfills the criteria as would now be set out therein. Also,
only one manner, the first line manner. So for petitioner number 1 is concerned manner. For her, I am not pressing manner. Stuck off manner. Petitioner number 1. There are two people. Oh, that will be there.
That will be
That
there.
will be there.
Doesn't make any difference.
The order passed earlier, the order passed earlier, it merges.
The interim order passed earlier stands vacated.
Okay.
41.
Lordship, I'm for
The learned counsel for the petitioner, although had undertaken to furnish a copy of the writ petition to the Standing Counsel Corporation Department, however, the same has not been done, although the said order was passed on 11/6/2025. So, the learned counsel for the petitioner, by seeking apology, has submitted that the said a copy of a writ petition would be furnished to the Corporation Department during the course of the day. Also, in the event the copy is not so served, this court would, on the next date of listing, consider as to whether the petitioner would be permitted to continue with the present writ petition. Also, registry to list these matters again after 6 weeks on a date to be fixed by you.
Obliged.
42.
This service will complete,
The response number 4 has come in. Seen the office note dated 29/5/2025, which reflects that the respondent number 4 on being served with a copy of the notice issued in the matter has entered appearance in the present proceeding and is being represented by Ms. S. Nath. Also, accordingly, registry to list this matter for admission hearing after 2 weeks. The respondents are at liberty to bring on record their stand by way of filing affidavits.
Basically, my lord.
Okay.
So, my lord, the IA is also posted in this IA because my lord.
We'll consider the whole matter together.
Yes, my lord. Kindly, my lord, may.
क्या लिखा है? 2 weeks, 3 weeks कर दो तो उसको 3 weeks. 3 weeks. Also, in the event the affidavits are not so filed, the you are for respondent number
8, my lord. 8.
The respondent number 8 would be at liberty on the next date of listing to press the interlocutory application being IA bracketed C 1578/2023 filed by him. So, registry to list this matter again after 3 weeks, immediately after 3 weeks on a date to be fixed.
Highly obliged, ma'am.
Just now I have space speaking on that, they have supplied to me, I'll go through it, let it come next week on any day.
Let us see whether that is required. It is between me and Imoli.
But 3 years they have suddenly passed the order when the earlier commissioner has transferred to another department.
You have not disposed it of. Where?
Plus,
Which one? Last page is something else.
accordingly, the representation submitted.
This one.
This is the earlier one.
Earlier, last, sorry.
That is there in your affidavit.
This is on also, as.
Nothing is here. Only representation disposal.
On the other hand, a perusal of the relevant document.
You challenge that, mister. This is not willful and deliberate violation. Is it willful and deliberate violation? No.
Pass the order, man.
They have passed the order. We'll close it, give you liberty. The present, I heard Mr. N. Sharma, learned counsel for the petitioner, and Mr. S. Dr. Learned. You are appearing for?
Number 1.
For the respondent number 1. So, Mr. Dr. has placed, and Ms. N. Bodulu, learned counsel, appearing for the respondent number 2. Mr. Dr. has placed on record a speaking order dated 31/7/2025, passed by the Additional Chief Secretary to the Government of Assam, Revenue, Roman and Disaster Management Department, disposing of the claim made by the petitioner in pursuance to the directions passed in this connection by this court wide order dated 12/9/2022 in WPC number 5021/2019. Also, On a perusal of the speaking order dated 31/7/2025, this court is of the considered that the directions passed by this court, while the said order dated 12/9/2022 has been substantially complied with. Accordingly, further, there is no willful and or deliberate violation of the directions passed by this court. Full stop. In view of the above position, this court is of the considered view that the present contempt petition need not be further considered. Accordingly, the contempt petition stands closed. Notices issued stand discharged. However, liberty is reserved to the petitioner to present a challenge to the speaking order dated 31/7/2025 in a manner in accordance with law, by filing by initiating appropriate proceedings in accordance with law. Also, a copy of the speaking order dated 31/7/2025 as furnished by Mr. S. Dr. is kept on record and marked as X. Done?
Yes.
45.
In pursuance to the in pursuance to the order dated 4/4/2025, impleading the National Highway and Infrastructure Development Corporation Limited as a respondent number 6 in the present proceeding, the petitioner has filed a amended cost title. Also, accordingly, petitioner to take steps for service of notice upon the newly impleaded respondent number 6 by way of registered post with AD. Also, steps within 3 working days from today. Also, on receipt of the requisition of our requisites, the petitioner, the registry to issue notice upon respondent number 6 in the manner indicated above. Also, registry to list this matter again after 4 weeks. 4 weeks on a date to be fixed by it. Upper when none appears for the petitioner link. Mr. H. Sharma, learned government advocate, appears for the state respondents.
46.
Please, your lordship, kindly give us 1 week of time to file memo.
Why this memo? Your computers are not working in your chamber. Then this order was passed in 18/12/24. You have committed contempt. How much cost? We are unnecessarily considering this matter. How much cost?
Lordship, by Monday, I will.
No. How much cost? Tell me.
Petitioner.
Where is your senior?
He's out of station. Lordship.
Out of station. I'm adjourning the matter. I'm not doing anything. File the affidavit. We are having it on Wednesday. Miss
AB Kayastha.
K?
AB Kayastha.
K?
AB Kayastha.
KB Kayastha, learned counsel for the petitioner submits that the matter be taken up on 6/8/2025, by which time she shall remedy the default occasioning on her part in the matter.
Yes, Lordship.
If the senior was here, I would have imposed 10,000 cost. 40? Yes. Why is the
It's complied with Lordship. We have passed the settlement.
My lord, yes, please still in
Page number 1, your lordship. Has been approved, your lordship, the deputy to the needful. The second page may be fit.
Respondent number 3.
Order is at page 12. So this was only with regard to a decision with regard to your prayer for allotment.
Settlement for a plot of land, my lord.
That's it. You had made a prayer. They had, this court had directed them to take a call.
Yes.
Now they have approved your settlement.
Yes, ma'am.
That's the end of the matter.
It is still under process, my lord, subject to deposit the premium, my lord.
And that is it, that you will have to deposit.
The respondents, they have not entered appearance till
Forget it.
My lord, after filing, after submitting the premium deposit, my lord, then
This decision was to be taken
yes, my lord.
that whether you will be allotted or not. Now they have allotted it.
Yes, ma'am.
So subsequently, the steps will be followed. Whatever, the decision of the government is already here.
Yes.
So what is more here? It's already complied with. If you have any further grievance, if they are not doing the steps, taking the steps forward, come back in the appropriate proceeding, we'll consider.
Maybe recorded, my lord.
Ms. A. Gohain, Mr. A. Gohain, learned counsel for the petitioner, and Ms. N. Bodley, learned counsel representing the respondent number 1 and 2. Ms. Bodley has placed before this court a copy of a communication dated 23/7/2025 issued by the Joint Secretary to the Government of Assam Revenue and Disaster Management Department to the District Commissioner, Kamrup bracketed Metro, wherein the decision of the government to accord approval for settlement of land measuring 2.7 ARE covered by DAG number 759 of village Guwahati, Sohor Guwahati, village Sohor, Guwahati, part 6 under Ulubari Moja in favor of the petitioner, subject to realization of settlement premium was conveyed. It was further noted in the said communication that land may be handed over and land records be corrected accordingly after realization of the settlement premium. Also, this court, by the order dated 29/9/2023, having directed the respondent authorities to consider the case of the petitioner in accordance with law and take a decision therein, and the prayer of the petitioner being for allotment of a plot of land, the same having been effected, this court is of the considered view that the directions passed by this court by the order dated 29/9/2023 has been substantially complied with. Also, there being no willful and deliberate violation apparent on the face of the records, this court is of the considered view that this court is of the view that the present contempt petition need not be further adjudicated upon. Accordingly, the contempt petition stands closed. Notices issued stand recalled. Full stop. It is provided that in the event the further course of action is not so proceeded with by the respondents, the petitioner, respondents concerned, the petitioner would be at liberty to institute appropriate proceedings in accordance with law for redressal of his grievance. For redressal of his.
48.
The cancellation of my legal
Okay, we'll come to your cancellation, Mr. But where the respondent number 3 has been served? What happened? Respondent number 3?
They have served.
We have served.
Where is that material? Who is appearing for respondent number 3?
We have been informed of that.
How have you informed him? File an affidavit to that effect by your competent authority. Huh?
Otherwise, my lord,
Otherwise?
they not maintainable also.
Yes, tell me why.
The owner, my lord.
Hmm.
The owner has not executed the lease.
Oh, only one co-owner has.
Yeah. The two co-owner has. There is a other co-owner in the patta, my lord. The patta is a title deed, my lord.
Submission is.
Yes, you clarify.
Milord,
That is why you are here.
Lordship. Lordship may kindly take up page 92, Milord.
92.
This is already reflected in the interim order also, Milord. But this point was raised at that point of time only. Page 92, paragraph number 3rd, Milord. Point 2, if your Lordship has, Milord.
Okay, let's see the interim.
As per field
Advertisement
order,
was issued for appointment
the
of
circle
Reconstruction.
officer measuring land measuring one cutoff from Dagna was muted in the name of Samsul Harnum, son of so and so, and land measuring one bigger so and so Dagna was
Barsa Hassa.
Barsa Hassa, son of so and so, in place of the partition by way of purchase. These two persons have purchased the land below. So question of co-owner does not come into play. I am the owner. These two persons have executed lease deed. So where is the question?
Got it. Heard Mr. Elal, learned counsel for the petitioner. Also heard Mr. S. Bothaku, learned counsel, appearing for the respondent number 1 and 2. Mr. Bothaku submits that he would file an affidavit through the competent authority of the respondent number 1 with regard to the service of notice upon the respondent number 3, and therein also bring on record the acknowledgement so received in this connection from the respondent number 3. Let the said affidavit be filed on or before 26/8/2025. Also, Registry to list this matter again on 1/9/2025. In the meanwhile, the respondent number 1 and 2 shall invariably bring on record their stand by way of filing an affidavit. Also, the other respondents are also at liberty to file their respondent number 1 and 2. Respondent number 1 and 2, huh? Other niche ola in contempt. Also, कितना तारीख को लिस्ट करने दिया? 26/19.
In the admission column, Milord.
For admissions. For admissions.
I am deeply.
Supplementary list 54.
My lord, private respondent filed one affidavit yesterday. And my lord, I have to actually required to rebut, my lord. Because some noise facts, my lord, they have stated. And my lord, I am very surprised to see that, my lord, one thing.
My only contention, Mr. Monto, here was whether the dumped materials have been removed on it.
Yes, that is
completely.
That has been removed, my lord. But tomorrow again they can do it, my lord. Why I am submitting, my lord? Your lordship kindly see. There is a various order passed by this honorable court to remove it because it's the municipality own order. Because there is a findings that, my lord, there is an inquiry report. There is a finding that it is a public road developed by the government by the 7th Pay Commission, my lord, 7th Finance Commission money. There is a developed, my lord. Now, my lord, your lordship kindly see, my lord, private respondent filed an affidavit and stating that, and one very important things, my lord, your lordship kindly see, Annexure F of the their petition, my lord.
Of your petition?
No, my lord, their affidavit.
Affidavit.
And para 22. That is a letter written by the council of the, my lord. That is in the hand of my lord, very same that is in the hand of my lord.
Where is that? Annexure F? Okay, 106.
From very beginning, my lord, there is an order to remove it. But that was not complied with somehow.
Whose counsel is Mr. Hemanta Kumar Sharma? That he has written. What is?
No, it is how it is. You go to the hand of private respondents. How it is go to the private respondents. Very same day, my lord.
Kindly look
between the.
No, my lord, I have explained. We have explained.
Oh, so.
Yes, page 22, my lord.
I have not served that affidavit. Anyway.
How did you send it? Through mail?
Yes.
No, this was sent to mail. Mail.
What's up?
WhatsApp. Your phone is hacked.
So that's why I want to reply.
The mail issue has already been settled.
No, let's say.
The
Yes, how did you know this?
Well, that the deponent para 22 page 13 mail.
Hmm.
That the deponent back to stated on 29/7/20. Suddenly, the officials of the Jurat Municipality Board, along with the police personnel, came to the private approach road of the deponent to remove the so-called dump material. And when the deponent questioned the authority of such action, the official informed that they are doing it on the basis of a direction and order passed by this honorable court on 28/7/2025, which has been communicated to Jurat Municipality Board by the Standing Council of the Board on 29/7/2025. And copy of the letter of the Standing Council delivered to the deponent. Otherwise, how will you get it, my
Okay. Mr. Sharma, both are contesting parties. We want to know from you. There is a road we see. Is it a private road or public? Mr. Is it a private road or a public road?
It's a public road.
Public road. Finished.
Because Lordship will.
There is the inquiry report and there is a final psychological report is there.
Where?
Page 60 of the
petition.
Page 60, my lord, second paragraph. No.
After letter, page 36.
page 35.
Page
35.
11 also, page 37. These are circle officers letter.
Okay. Mr. Ghosh, what is your material to demonstrate that this road is a private road?
My lord, lordship will kindly see paragraph, my lord. This land was, my lord.
Okay, show me the material.
Yes, my lord. The land was, my lord, lordship may kindly look.
Your land varies anywhere, but where is that material?
Lordship may kindly look to paragraph, my lord, the 5 of my affidavit.
5.
We have stated how this road was carved out, my lord. Paragraph 5, my lord, page 3.
Okay.
We have to, my
So
lord.
now, basically, by this action,
Yes.
your private property has been usurped by the government and by Mr. Sharma. By
Yes,
Mr.
yes.
Sharma.
I'm,
At the instigation of Mr. Mohanto.
I'm not saying that, my lord. I'm not saying
That is what it's coming out.
my lord.
So you have been dispossessed of your land. Road is also a land,
Yes.
which is your right.
Yes.
Go before the civil court. Establish your right. Go before the civil court. Establish your right. Finish it off. Till that time, don't make any construction on the
No disturbance.
no disturbance.
Already before the government, my lord, there is a problem.
That will not do. You will have to have a declaration that this land
My
is
lord,
yours.
lordship, when a road is to be declared as a public road, there is a provision under section.
They
157.
say this is you had gone before the circle officer. You have not been able to
So any
demonstrate
document, any document.
that this land is yours.
My lord, I've annexed the documents, my lord. I've annexed the document.
Why should we look into it for the first time?
There was no.
Let the
objection.
appellate authority decide the case on merit.
Not the appellate authority. If you have anything here,
Inquiry was conducted.
go
as
before the
direction of
civil court.
appellate authority.
Huh?
No.
Inquiry was conducted as per direction of the appellate
Inquiry.
authority.
No, my lord, I should kindly see the inquiry report then.
Why was
What
it
is
not-
debate?
Go by the record.
Page 60, my lord.
No.
Page 60, lordship, kindly see.
Of the petition.
Yes. Para 2, my lord. Paragraph, second paragraph. Accordingly, lordship will kindly see last part, 2 lines. Accordingly, my lord has got it.
Page 60.
60, my lord.
Huh.
Accordingly, the matter was inquired. It is as per the direction of the appellate
You are
authority.
Yes.
you are
Yes.
looking for. You are asking me to look at which part?
Paragraph 2, my second paragraph, my lord.
Okay. Accordingly,
Lordship has got it.
accordingly, the matter was
Accordingly,
in.
the matter was inquired into. During inquiry, both the parties, the appellant and respondent number 1, claim their right over the land relating to the road.
Hmm.
So where from it is the public road, my lord, if they are also claiming.
Why, Mr. Monto, you are claiming that road?
Yeah.
You are claiming it as a public road.
Yes, it is a public road. I'm not claiming as a land, my lord, for me. It is a road. Let it be remain as a road. That is developed.
He is claiming it is a land
My
of
lord,
his
let him
own.
finish, then I'll argue, my lord. Why you are saying no?
No, Mr. Ghosh,
Worship.
if this is your private land,
Yes.
why the government had made construction over that land?
My lord,
Why have you not objected?
government can, section 155 may lordship may kindly see.
What is it? Read.
I am
Read.
reading my,
Hmm.
I am reading lordship. will see. There is a procedure, my lord. Section 155 of the Assam Municipality Act, my lord. Power to require repair of roads and drains and to declare such roads as drain and passage. When the board considered that in any road or drain not being a public road or drain, whether or not previously labeled, played, metal, channeled or severed or repaired or not previously labeled so-and-so, severed or repaired out of municipal or other public funds, or in any part of such road or drain within the municipality, it is necessary for the public health, convenience and the safety that any work should be done for leveling, paving, metalling, flagging, channeling, draining, lighting or cleaning therefore, the board may with written notice require the respective owner of the land or the building fronting, my lord, adjoining or abutting upon such road and drain or part thereof to carry such work in a manner and within the time specified in such notice. Now, my lord, 155(2), if such notice is not complied with, during the time specified, the board may, if it thinks, execute the work mentioned or referred therein and may, if thinks fit, recover the provision recovered under provision of section 149 of expenses incurred in doing.
No, they are not recovering any expenses because they say that this is a public road.
No, my lord, then lordship will say, subsection 3. After such work has been carried out by the owner, where provided under section 2 by the municipality board at the expense of such owner, the road or drain part thereof in which such work has been done with the consent of the owner be declared to be a public road. What is the consent of the owner, my lord? Let them, municipality shows.
First, you establish that this is your road.
I have established, my lord, I have filed all the relevant document, my lord. In CLD, it is provided that a path was given to me. My lord, that is, lordship will kindly see the photograph, page 105. Lordship will kindly see the photograph. My lord. Lordship kindly see. It starts from 104, my lord. My lord, this 104 first photograph is the main road. That is the public road. And I know next, my lord, there.
Where is your house here?
My house is inside, my lord. In
Which
next
one?
photograph, my lord. This is the road which they are saying to the public road, which
Which one?
accordingly is not a public road.
So these people
Yes.
who are having houses here,
Yes.
which
it
is the road they use
Uh,
for ingress and egress? What?
Only those people, my lord, because they purchased the land from the owner and they provided this portion, my lord. That is
Okay,
the
where is the petitioner situated? Where is the petitioner situated here? In this photograph.
petitioner? This one, my lord, lordship kindly see. That is the main road. First photograph. This is the main fancy alley road. That is the public road.
That green color building.
Yeah.
That is the petitioner's house.
Oh, yes.
Mr. Monto, that is your house.
Hey, my lord, that's why I want to respond. They have given me, my lord.
If this is your house,
No, my lord. Your
whether
lordship-
they have dumped material here, site, what harm
Your
is?
lordship kindly see my photograph, my lord, which I have annexed, my lord. They have, after,
Material, what we
no,
want.
that is your lordship kindly see that. That's why I want to give reply to that, my lord.
Okay, fine. Your page 22 and 23.
Your lordship kindly see.
22, 23.
Page, my lord. Your lordship kindly see that.
22, 23.
Page 60.
Original photograph, which was there before they metal. Municipality board metal the road.
Municipality already inspected and they are doing it. Thereafter they have, my lord.
No, where is your house situated? Is
My
it
lord,
on that road only?
No, but now there's photograph I came to know, my lord, just now.
Let them reply.
That's why I want to give reply, my lord.
Anyway, they have now cleared it.
Yes, they have cleared it, my lord. No, my lord, if your lordship go, my lord, what they are doing, my lord, your lordship kindly see page 65, my lord, my petition. Page 65. That is, my lord, how they block my gate. That is the road, my lord. They are dumping material, my lord.
So, but your gate here this is a different.
No, that route is used by all, my lord, not only me, my lord. That is a public route. Otherwise, my lord, for one person, that route cannot be.
No,
used, my
you
lord.
have a ingress and egress from the main road.
Yes, there is the.
And you have another gate here also.
No, there is another side, my lord. That is not my.
Here, that gate is there. No vehicle can come out from this gate.
Yes. They are by dumping, my lord. By dumping, they are material. They have. My lord.
Mr. Ghosh.
My lord, let me. My lord, I'll explain it. Let me file it. No, my lord. Let me file it.
No, Mr. Monto, for in your affidavit, you have a exit towards the main road.
Yes.
And you have an exit towards this.
Yes.
Small road.
Yes. That is another side, my lord. That is my house is there, my lord.
So this is the main gate for you.
Yes. This is one of the gate, my lord.
Okay. One of the gate.
That I've explained. No.
Mr. H. Sharma, Learned Counsel for the Jorhat Municipal Board on instructions has submitted that all the dumped materials which were required to be removed from the site by this court, by wide orders passed in the present proceeding, has since been removed. Mr. T.J. Monto, Learned Senior Counsel, appearing for the petitioner, has submitted that this court would be further required to pass a direction upon the respondents, more particularly the private respondents, not to create any further obstruction in the road in question. First, the said prayer is objected to by Mr. B.J. Ghosh by referring to an affidavit filed in the matter and contending that the petitioner is in no way, the petitioner's ingress or egress is no way obstructed on account of the storing of materials on a plot of land used.
Not problem. It's a road, madam. It's a public private road.
Wait. On a plot of land, used as private land, used as a private road by the private respondent. Also, Mr. Monto submits that, Learned Senior Counsel submits that he would file an affidavit in reply to the affidavit in opposition filed by the respondents number 9, 10, and 11, and therein demonstrate that the said road, Mr. Monto demonstrate that the said road is not a private road, but a public road, and the petitioner also requires an ingress and egress.
Public road used by public.
It requires an ingress and egress through the said road also. You also require an ingress and egress. Till the said affidavit is filed and this court considers the matters issue arising in the present proceeding, the parties are directed not to obstruct the road in question by dumping any material therein.
Shall be maintained.
Therein till the next date of it. Don't dump any material, both parties, till the next date of this thing. Done.
But he also not.
Oh, he will not do. He will not do. You come and tell us, I will take care. You come and tell us, we will take care. That is why I said parties. Otherwise, you would have to reverse the situation. You would have come there, he would have come here. So I don't want that to happen.
That municipality obtain instruction or that comply with section 155 of the municipal tax. That should be there, my lord.
First, let us see what Mr. Monto brings on record with regard to private and public.
Yes, but their affidavit is required, municipality board affidavit, my lord.
If they don't file, we will go by non-traverse, and your statements are already there. And if there is much dispute, it becomes too heavy for me. I'll send you to the civil court.
Can I get this?
Yes. Mr. Monto, whether public, private, now you...
No, private, public, that is already decided, my lord. Now, my lord, they have nothing.
Private road.
For the first time here, my lord, they have, my lord, given this one.
Why? One affidavit copy maybe have to be.
Which one?
I will find it.
Madam Gogoi will sign.
Yes.
Hopefully, you are in talking terms.
Yes.
Madam, if I may make a mention, Madam.
Yes.
Madam, in the morning I made a mention of item number 55, my lord, seeking adjournment. However, I forgot to advise your lordship, there is an interim order till date to that.
55.
55, madam.
Silent person. In the cut question. Sign question in I got. Interim order, interim order if any to continue till the next date of this.
Obliged, madam.